and Sarah. Good morning, everybody. I think we're in. Those of us that are coming in are in. Thank you, Gina. Well, good morning. My name's Melissa Castan and I'm a professor in the Faculty of Law at Monash University and the director of the Castan Centre for Human Rights Law. Oh, that was good. Thank you. I do want to begin by acknowledging the Wurundjeri Woiwurrung and the Bunurong people of the Kulin Nations on whose lands we meet today, and I pay my respects to their elders past and present and extend that acknowledgement and welcome to all First Peoples who are joining us this morning. As we meet today, we acknowledge that the law and its ramifications play a very significant role in the lives of First Peoples in Australia. And it's our obligation as practitioners and students of law to recognise the role and impacts of Captain Cook's law, the Anglo-Australian law, on First Peoples. I recognise that there have been attempts to undermine and negate the importance of welcome and acknowledgements protocols, and in my view, this is an important aspect of restoring proper legal relations within our law and political domains. I'm particularly cognisant at this conference last year, we heard from proud Gunditjmara man Reuben Berg, co-chair from the First Peoples Assembly of Victoria. And in his keynote, Reuben spoke powerfully about the need for treaty in this state. And since then, we've had the handing down of the final report of the Europe Justice Commission earlier this month. And I want to acknowledge and thank the commissioners for their work and all the people that worked on those reports and contributed, including our former Director Professor, the Honourable Kevin Bell, AOKC, who was a former commissioner. We've also had the news recently of the granting of a World Heritage status to the Bunjil Bim cultural landscape in the land of the Gunditjmara people, and the granting of exclusive native title to traditional owner groups in northwest Victoria. And these are important stepping stones towards a re-establishment of proper legal relations. We commit ourselves to listening and to action as we move towards a treaty here in Victoria. And as Professor Kate Aughty wrote last week in the Alternative Law Journal, please read the UROC report. Please choose one recommendation of the UROC report and follow it, advocate for it, write about it, make it happen. It's on us. We have been asked to do this work and we don't need to ask permission to support First Nations and justice in Australia and Victoria. That being said, I would now like to welcome the Dean of the Faculty of Law at Monash University, Professor Stephen Vaughan, to open our conference. Stephen has asked me not to talk endlessly about him, so I will do as instructed. But Stephen joined us just 6 months ago, having previously worked at University College London, where he was a Professor of Law and Professional Ethics, and he held a number of leadership positions there. And I'll stop then and hand over to Stephen. Thank you, Stephen.
Good morning. How lovely it is to see all of you here, friendly faces and new faces. This will be a wonderful conference. Let me thank Melissa for her brief introduction and for those very powerful words of acknowledgement. As someone English and someone white and someone new to these lands, I'm very reflective of all the learning that I need to do and also the potential that I have as the Dean of a law faculty. When we did the sound check, Melissa said she would introduce me as Dean of the Century. She didn't do that then, but that's fine. That's slightly offensive. Also, it's only 2025, so I'm not sure what that says either. In the conversation quarter a moment ago, someone said, "Oh, I've heard that you're funny." And I said, there are no jokes today because human rights is not funny. So let me begin by offering some public congratulations. Back of the room is Associate Professor Julie Debeljek, who has taken over as Deputy Director of the Centre, taking over from the person sat next to her. Obviously, deputies and former deputies need to be in close proximity. Associate Professor Ronley Sifrus, who has gone on a temporary basis, I stress that, on secondment to the Australian Law Reform Commission. In the front row, I also happily note that we have Sarah Joseph, Professor Sarah Joseph here, former Centre Director. I had a list of other great and good people in the audience, and I'm not going to read it out because I once did that and didn't quite notice Lady Hale at the back of the room. Just not willing to make that mistake again, so we're not there today. The Vice-Chancellor of Monash, Professor Sharon Pickering, asks the same question of her deans over and over again. And what she says is, what is it that your faculty does better than anybody else? And being the dean of this law faculty, I have lots of things with which to answer that question, and one, of course, is the Castan Centre. Celebrating its 25th anniversary this year, what I find so inspiring about the centre is what I think is at the core of Monash law, the use of expertise to make a difference. Sir David Derham, who was the first dean of the faculty, said, quote, "Law is deeply embedded in society. Unless it's working for society, it is missing the point." Well, I think we can extend that and say that unless lawyers and legal academics are deeply embedded in society, unless they are working for society, unless lawyers, legal academics, judges, coroners, activists, all of us, then we are missing the point. And that point is certainly not missed by the Castan Centre, its enduring commitment to using rich and deep expertise, influencing government policy, legislation, providing accessible public education on human rights, giving our students, many of you alumni here, with outstanding opportunities. And this annual conference, I'm told it's a date in the diary for everybody, is a good example of those aims and activities, bringing together this collective brains trust of expertise, advocates, lawyers, for powerful evidence-based discussions. And it strikes me that this centre and each of you are so critical. Critical to defending the rule of law against populist undermining, critical to promoting evidence-based discussions in an age of misinformation, and to having hard conversations about very complex and contested issues in a pluralistic society in which we disagree about lots of things, and critical to creating transnational solidarity, legal capacity, encouraging intellectual and other forms of resistance. Put another way, I am so excited to see how the Castan Centre moves forward with its members, with our students, with all of you, on its already exceptional foundations. To formally begin our proceedings today, I'm handing back to Professor Melissa Castan as Director of the Centre. You know her, of course, as a leading scholar on constitutional and Indigenous rights law, and as the daughter of the late Ron Castan AMKC, whose groundbreaking advocacy helped shape Australia's human rights landscape. Melissa carries forward his legacy through her leadership, her teaching, her commitment to justice. She is one of my many wise counsellors inside the faculty. Thank you, Melissa.
Thank you, Stephen, for those very generous opening remarks. Every time this happens, I get into a hot flush and I don't know what to do with myself, so I'm just going to read out what I'm told to do. Thank you, Scott. So thank you, Stephen. It is my honour to work at Monash University and to lead this centre and to continue to advocate for a more just world where human rights are respected, protected and fulfilled, and allowing people to pursue their lives in freedom with dignity. We work on, of course, education, but also in policy and law reform for the benefit of communities around us, and we seek to provide accessible public education on current and important issues. And I'm so pleased to be able to welcome back Julie into the leadership team of the centre. Our team altogether, including all the academics and professional staff, continues to work to deliver outstanding research and meaningful interventions in human rights law in Australia. It has been a very full 12 months for our centre since our last conference. We've made a number of important submissions on anti-vilification laws and changes to state and federal parliamentary regimes. We've been before parliamentary committees and UN bodies. We've worked on issues of judicial ethics, engaged on surrogacy law, and continue to educate the next generation of human rights leaders at the undergraduate, postgraduate and PhD levels. And just recently we were very pleased to be able to contribute to the NGO Coalition report for Australia's upcoming Universal Periodic Review, which will happen around 6 months from now. So I wanted to genuinely welcome each of you who are here in person. It is wonderful to see you. Some I'm seeing again and some seeing for the first time. And welcome to all our distinguished guests again, who I will not read out lists of for fear of getting it wrong. But I also want to welcome the people who are joining us on the live stream. I think there's some 70 people out there in the internet somewhere watching us, so I hope that you're seeing everything clearly. And if you're not, I'm sorry, I just can't deal with it. Speak to Michael upstairs. But I hope it's all going smoothly. Yes, it is, isn't it? Thank you. Your fellow members in the audience today include local, interstate and international attendees from the legal profession, from the human rights sector, from government, from academia, including law students from across Australia. And I'm delighted that you're all here today. And it's so important that we gather together regularly or semi-regularly to re-establish these relationships. So I would ask you today to make sure that you go up to somebody you don't know and introduce yourself and make a new connection with someone, and equally they will do it back with you. You've all seen the program. I think it looks something like this. This morning we're very pleased to hear from Hugh de Kretser as he delivers our keynote, and we'll follow with a panel discussion with our former director, Professor Sarah Joseph, and talk about how we might achieve stronger human rights protection in Australia, and then we will have a break for morning tea. The time frames are very strict. Someone will say to you in a stern voice, please go back into the auditorium. And then we'll have our second panel on recent challenges in securing rights of trans and gender diverse people, led by my colleague, Professor Paula Gerber. We'll then turn to legal strategies for climate justice, which continue to be the focus of public and legal attention, as it should be. With cases in Australia and international venues decided in the last few days, we have renewed focus on this. And we will have our panel on new challenges in climate change litigation and human rights. And then another short but very enjoyable afternoon tea break. And we'll come back for our final session on understanding human rights law in the coronial jurisdictions. Coronial work has a critical role in justice and in transparency and accountability in public law, and I hope that we'll have the opportunity to discuss the extent that human rights are made explicit and implicit within the coronial context. So I invite you all to engage actively today and encourage people to ensure that conversations are free-flowing, respectful and inclusive. And I hope that we will have time at the end of the sessions for audience questions. There will be student volunteers around to pass you a microphone so people can hear what's being asked. If you're on the, if you're asking questions and you're in the auditorium, you won't be seen on the live stream, but your voice will be heard. So if you'd like to ask a question anonymously, just write it on a slip of paper and sort of wave it around, and someone will come and grab the paper and we'll put that through from the chair. And most importantly, if you're here in person, the bathrooms are out that back door and then to the right through the foyer. The evacuation instructions are, don't panic, someone will tell us what to do. And our breaks will happen in the conversation quarter where a few of you were this morning. That's out that way and to the left. And it's a big space, so please make yourself comfortable there. Eat all the food that we've so carefully accounted for by counting every person. And if you have special food requests or needs, please make sure you make that known to the people there. So it's now my pleasure to introduce Hugh de Kretser to deliver his keynote to us. Hugh commenced his 5-year term as President of the Australian Human Rights Commission this time last year, and for more than 2 decades, Hugh has been working in critical roles advancing human rights in Australia. Before joining the Commission, Hugh was CEO of the Europe Justice Commission, and previously he worked as the Executive Director of the Human Rights Law Centre. Hugh also asked me not to read out a long bio, so please just Google Hugh and you'll find out all the things that he's done. But please can you join me in welcoming Hugh to the stage. Thank you.
Morning, everyone. It's fantastic to be here. Flew in last night. I now live in Sydney as from January. Melbourne feels like home, and there's so many amazing, friendly faces in the audience, people I've worked with for a long time, people I work with now at the Australian Human Rights Commission, so it's great to be here. Keep me in check if I start to feel that sense of smug superiority of now living in Sydney, where the weather's better and the city is more beautiful. But what is keeping me in check is my mum. I stayed with mum last night in the house I grew up in, and as I left, she was looking at me saying, "You're not wearing enough clothes. You'll be cold. Please take a jacket. Are you wearing thermals under your top?" And as I was sitting before, she sent me a text which says, Hugh, you have left me deeply disturbed about your totally inadequate clothing for this cold, cold Melbourne day. I have so many good-looking warm coats, I'll bet you even probably don't have a fold-up umbrella in your bag. You're forgetting it is Melbourne, cold wind and cold rain. So there you go. The life of the President of the Australian Human Rights Commission. And I acknowledge Gillian Triggs, who's here today, and just big thanks to the people who teach in law schools and inspire people like me to pursue careers in human rights. Gillian taught me international law, and teachers like her and Tim McCormack, there you are, Gillian, absolutely inspired me in my career. You only gave me an H2A on my essay on the Helms-Burton Act, so we need to take that up later. But people like Melissa and Paula Gerber and Julie Debblejack and others, fantastic, inspiring teachers, Sarah Joseph, and thank you for the work you do. And I've been a long admirer of the work of the Castan Centre, and we've worked closely together in previous roles, so it's fantastic to be here. We're on Wurundjeri country. I acknowledge Wurundjeri elders and ancestors and their continuing and ancient and ongoing connection to country and their culture. We talked about, Melissa spoke about Yuruk. One of the best work days I've ever done in my life was on Wurundjeri country out in the old Corrandirk Mission Reserve. Next to what's now Healesville Sanctuary. There's a beautiful clearing there surrounded by ancient manna gum trees that would have been standing there before Europeans ever walked on this land. Tree ferns, beautiful creek going past it, and it's the place where Wurundjeri elders like Arnie Dai Kerr and Arnie Irene Morris have restored the women's and girls' coming of age ceremony. A long tradition that had been broken by colonisation, which they've brought back. And it's the place where, working with Wurundjeri elders, we held a sort of informal hearing with the Premier of Victoria, Jacinta Allen. She sat down with Wurundjeri elders and the girls and women like Mandy Nicholson, and they talked about the importance of culture. The girls talked about how the restoration of culture and participation in that ceremony and their connection to culture had improved their well-being and confidence and identity. And that speaks to the power of restoration of culture, it speaks to the power of truth-telling, and it speaks to the importance of processes like the Yuruk Justice Commission and that need to be replicated across the country. I want to start by talking about the upcoming UN review of Australia's human rights record. It's called the Universal Periodic Review, and it happens every 5 years at the UN Human Rights Council in Geneva. The UN Human Rights Council is like the world's human rights parliament, and the UPR, or the Universal Periodic Review, UPR for short, is a peer review process. So each of the I'm going to grab a... I feel like my mum would be saying, have a glass of water. Yeah. So it's a peer review process. So once every 5 years, each nation will have other nations look at their human rights record and then ask questions and make recommendations to those nations. And nations are expected to respond to those recommendations. Last time in 2021, during COVID, all done online, 122 states made around 250 recommendations to Australia. The Australian government supported 177 of the recommendations, and the Human Rights Commission's assessment is that it's fully implemented only 6% of those recommendations, and partly implemented about another 86%. The review is a good time to take stock of Australia's human rights record, where we're at and where we need to get to. The Australian Government provides a report outlining progress and regress since the last review, and then the integrity of that process is bolstered by a report from the National Human Rights Institution, in our case the Australian Human Rights Commission, and a report by NGOs. And the NGO coalition, led by the Human Rights Law Centre and others, and endorsed by I think over 150 NGOs, was submitted last week and made public on Monday, and our report was submitted last week and will be on our website shortly. Working with NGOs, we'll brief UN member states on our views on Australia's human rights record and things we need to improve and recommendations they should make to Australia. The review also has input from UN treaty bodies and experts. It's not a perfect process, but it's an important international accountability mechanism and important for the Australian public to see that scrutiny around our human rights record. So how's Australia doing on human rights? The last time we were reviewed in 2021, we were deep in the COVID pandemic. Australia's responses to the pandemic undeniably saved thousands of lives, and in many respects, we outperformed many similar nations around the world. But in some respects, like international travel restrictions or the North Melbourne Towers lockdown, we went too far in limiting people's rights. And the Commission published a report earlier this year on our record in the pandemic around protecting people's human rights. Over the last 5 years, there's been some important progress on other issues. We've had the implementation of the Respect at Work reforms to address sexual harassment and sex discrimination in Australian workplaces. This includes amending the Federal Sex Discrimination Act to have a greater focus on prevention through a positive duty to eliminate unlawful conduct, sexual harassment, sexual discrimination and the like. The Commission is now the national regulator for the positive duty. Got some of the team here today doing fantastic work. We've had the expansion of gender equality reporting to the public sector and the expansion of budgeting processes, making a budget focus on gender equality. We've had the establishment of the new national plan to end violence against women and children. We've had the commissioning or progressing of responses to a range of royal commissions into abuse of people with disability, aged care, robo-debt, responses to the former Institutional Child Sex Abuse Royal Commission and the Royal Commission into Defence and Veteran Suicide. We've had the establishment of the National Anti-Corruption Commission and the National Administrative Review Tribunal with a stronger focus on systemic reform to stop things like robo-debt. We've had funding given to the Australian Human Rights Commission to set up the National Anti-Racism Framework, which I'll talk about in a sec. We've had progress on some of the closing the gap targets. It's important, closing the gap is often criticised. I think it's very important to recognise where we are succeeding. And with some of those measures are on track, particularly early childhood education, employment and land rights. And Melissa talked about the native title claim in northwestern Victoria. Other measures like Year 12 attainment and tertiary education completion are improving, but not fast enough to meet the targets. Progress on truth-telling we've seen in Victoria, progress on voice in South Australia, and the Victorian Government and First Nations are negotiating a treaty now in Victoria, so there'll be progress there shortly. We've seen the end of temporary protection visas for refugees, and we're seeing commitments to address climate change with a legislative goal of reducing emissions by 43% from 2005 levels by 2030 and to reach net zero by 2050, noting that this is not enough to avoid massive impacts from climate change on people's lives here in Australia and globally, and we can talk about the ICJ decision in the panel. The Albanese government has also made election commitments to improve Medicare, housing, access to childcare, as well as to improve higher education by reducing HECS debts and improving accessibility to TAFE. On regress, unfortunately, Australia's gone backwards on many issues. Racism has risen in Australia, linked to the failed voice referendum and also to the war in the Middle East. Most of the closing the gap targets are not on track, and some, like First Nations imprisonment and child removal, are going backwards, and that is a national disgrace. Northern Territory and Queensland in particular are leading a race to the bottom on criminal justice policies. The Northern Territory has just reintroduced unjust mandatory sentencing laws that make it harder for courts to ensure that the punishment fits the crime. Queensland has abolished child rights protections to remove the principle that imprisonment of children should be a last resort. There's been limited progress on raising the age of criminal responsibilities. One of the big focus points of the last UPR was many nations recommended to Australia that the age of criminal responsibility should be raised. Still, most jurisdictions, including the federal jurisdiction, allow children as young as 10. We're talking grade 5 primary school kids to be arrested, prosecuted and locked up. And of course, we know that these are not laws that affect communities equally. It's the First Nations communities who bear the brunt of this. Victoria has raised the age to 12, and the ACT has very recently raised it to 14, with some exceptions. The Northern Territory, however, recently lowered the age from 12 to 10. Queensland also abolished its truth-telling inquiry and its treaty process, and at the national level there's been no progress on truth-telling and treaty. And Australian laws still permit asylum seekers arriving by boat to be turned back without any proper assessment of their refugee claims, and those who do make it to Australia, including children, must be detained and then sent offshore to the tiny island nation of Nauru. So how do we better protect human rights in Australia? Part of the process in the lead up to the UPR, which will happen, Australia's review will be in January next year, is that states are expected to make voluntary commitments, promises about what positive action that they will take to improve human rights protection in Australia. And the NGO Coalition and the Australian Human Rights Commission will be engaging with the Australian government to suggest things that they can do to improve human rights. Australia will also respond to the recommendations made by other nations, choosing which ones to accept and to implement. So what should Australia be doing? That's a big question, and a big part of the answer is in work already done by the Commission, NGOs and others. And either on your seats or at the front desk, there's a booklet which the Commission's produced, which outlines 7 ways that the Australian government should, 7 actions that the Australian government should take to better protect human rights in Australia. And this comes from our multi-year Free and Equal project, which was finalised in 2024. Number 1 is to adopt a Human Rights Act for Australia, legislation that protects in Australian law the rights that Australia has promised to protect at the international level. We also need to make our national anti-discrimination laws more effective and comprehensive, and with a much stronger focus on prevention rather than relying on individuals to change unjust systems. We need to establish a national human rights education action plan. We need to improve the parliamentary scrutiny of human rights. We need to support the establishment of a human rights tracker, a way to measure progress and regress on human rights, a bit like the Closing the Gap framework, but for all Australians. We want government to deliver an annual statement to Parliament on its human rights priorities, and we want government to increase support for civil society and the Australian Human Rights Commission to be able to better protect human rights. The Parliament's own Human Rights Committee, the Parliamentary Joint Committee on Human Rights, recently looked at how to better protect human rights in Australia. And in 2024, it recommended establishing a Human Rights Act, drawing heavily on the Commission's model. And the government hasn't formally responded to that recommendation. It says it's in consideration. The Disability Royal Commission also looked at the Human Rights Commission's Free and Equal work and adopted much of our work in its own recommendations to improve the Disability Discrimination Act, and we're expecting government to announce consultation around that shortly. Last year, the Commission published the National Anti-Racism Framework. It's an ambitious document that draws on extensive community consultations and research to make 63 recommendations to government and beyond to eliminate racism in this country, and it's needed now more than ever. The priority is getting government buy-in to establish a task force to work through each of the recommendations and to build an implementation plan to get them done. This is just a snapshot of some of the actions that we hope government will commit to. There are so many more things we need to do to better protect people's rights in Australia, from ending deaths in custody, ensuring independent investigation of police misconduct and police-related deaths and other deaths in custody, tackling the dangers of new technologies like AI, neurotech and social media. I want to finish by sharing some reflections on human rights advocacy and some comments on Australian values. As I've got older and my career's got longer, I think I've got better at understanding how positive social change happens in this country. I don't think that the law and policy reform process is taught enough in our schools and university. And for me, it's been a personal journey of understanding. When I started in community law back in 2003, at first it was about helping people to get individual results and win cases. We were making a difference for individual people, but I quickly got sick of doing what felt like band-aid solutions in a system which was unfair for many of the clients we helped. I was lucky to work with amazing advocates like Amanda George, who taught me about law reform, community development and social change, and that became my passion. When I started at the Victorian Federation of Community Legal Centres, I reached out to an experienced and excellent Victorian public servant, Chris Humphreys, for his advice on how I could learn about policy reform and the social change process. And he recommended a book to me, John Kingdon's seminal work on public policy. And the central thesis of this book is about policy windows, moments in the policy cycle where you have an opportunity for change. Kingdon says that a policy window opens when three things align. The problem is well understood by government, experts, and the broader community. The solution is available and feasible, and the political will is there. For people advocating for human rights reforms, the message for us is collectively we need to do our policy work. We need to be credible and trusted. We need to have the right relationships, and then we need to be ready to move quickly when a policy window opens. And I think I look at the human rights sector as a whole there, because I think different organisations can play different roles in those objectives. Often policy windows will open unpredictably and quickly, and often they will close very fast. I remember at the last UPR cycle, when I was at the Human Rights Law Centre, looking at what voluntary commitments that might align with what the Morrison government might want to achieve. And I thought the implementation of the Commission's Respect at Work recommendations around eliminating sexual harassment in this country was a good fit, and advocated for them to make voluntary commitments around that. And we didn't get any traction whatsoever. Then there was the international and domestic focus on women's rights brought about by the Me Too movement, the women's marches for justice, and the powerful advocacy by Brittany Higgins and others. This raised the public and political awareness of the problem and made political will happen. The Commission's recommendations meant that there was a ready-made solution available and feasible, and the relationships were there to enable them to be implemented. The policy window opened, and government quickly committed to the Respect at Work reforms and a range of other positive reforms. And across both the Morrison and Albanese governments, all of those reforms have now been implemented. So many human rights changes happen this way. Years, and sometimes decades of hard strategic advocacy, campaigning and legal action are often involved. Often there's inches forward and inches back. Sometimes we're just trying to hold the line to stop bad things from happening, and then waiting for that moment where the window opens and then you can move and the change can be won. Working as a commissioner at the Victorian Law Reform Commission back in 2008 to 2012 also taught me the importance of understanding the perspectives of all the different interest groups contributing to different policy reform processes. If we want government or business to take up a reform, we need to understand the perspectives of those who might oppose some or all of that reform that we're proposing. If we don't agree with their perspectives, we need to be able to explain to government why they should prefer our approach. We also need to look for compromise, common ground, and consensus to make it easier for government to implement reforms. Maybe in the panel we can talk about why the Human Rights Act hasn't been accepted now, and look at some of the interest groups who have opposed that and why we need to engage with those groups. I was at Uruk when Uruk Justice Commission when the Voice referendum happened. And it was heartbreaking turning up to work the next day after that no vote and seeing advocates like Arnie Eleanor Burke, the chair of the commission, who had spent her life advocating for First Nations rights. And I was devastated for her and First Nations colleagues, and in her very wise way, she said to me, Hugh, these things are beyond our control. And it was a way that helped me to process the disappointment of that loss. And that's not personal for me, I'm not First Nation, so the disappointment for her and her communities and First Nations communities across the country. And I was lucky to have a job to address the reasons why the Voice referendum failed. And for me, it provided a sense of purpose and energy. And I looked at the survey research around why people voted a certain way, yes or no. And one of the questions that was asked by survey research done by our Sydney Morning Herald and The Age was, do you think colonisation has been good, bad or mixed or unsure for First Nations people? Working at Yurok, with all the devastation we had seen in terms of the massacres, the land theft, the suppression of culture, the suppression of language, the removal of children, mass imprisonment, ongoing child removal, the answer to that question is obvious. But when I looked at those results, it showed that twice as many people thought that twice as many Australian people in this demographically represented sample thought that colonisation had been good for First Peoples, about 40%, and about 20% said they thought it had been bad, and about 40% were in that mixed or unsure category. And that moment for me was a realisation that all the time that we had spent crafting the best informed policy solutions to fix over-imprisonment or to fix bail laws or to fix land justice or the education system, those recommendations will not have, I was going to say will not go anywhere. They still have a chance of success, but that chance is massively diminished if the Australian public does not understand the reason why we need those reforms in the first place. And for me, the voice referendum, that one question and the answer to that question helped to explain why, in John Kingdon's terms, the problem wasn't well understood enough by the public. This is why truth-telling is so important, and if you haven't read particularly the final report of the Yurok Justice Commission, it's reports that have recommendations in it. I hesitate to say this, but I'd say the most important thing for people to read is the Truth Be Told report, which is a masterpiece. It's written by a First Nations writer, Daniel James, Yorta Yorta, descendant of Lance James, who was the teacher at the Yorta Yorta mission, Maloga mission, and it is incredible. It's history told from the First Nations perspective. It's the history of Victoria told through First Nations eyes, and it's extremely powerful, and my hope is that it helps to bring about that understanding that then enables change. And if you prefer TV, Bridget Brennan's Four Corners episode on Yurok is still available on iView, and it's fantastic. I want to give you some good news and hope, and when I looked at those results after the referendum, I looked at what understanding there is in Australia of injustice against First Peoples, to try and take an evidence-based approach to where we focused our attention. And there is really good understanding of the injustice of the stolen generations. Why? Because of generations of advocacy by survivors, their families, communities, and the organisations that represent them. Why? Because of the 1997 Bringing Them Home report by the Australian Human Rights Commission, which documented their experiences and made recommendations for reform. And my predecessor, Rosalind Croucher, would talk about this report in terms of the long arc of justice and the long arc of the implementation of some recommendations from bodies like ours. The Howard government rejected the Bringing Them Home report, but fast forward to 2008, and that report led and contributed to Prime Minister Kevin Rudd's apology to the stolen generations in Parliament. I was standing down in Fed Square when he made that apology. A fantastic day. And then you can fast forward from 2008 to the establishment of redress schemes, compensation schemes for stolen generation survivors. Now, with Western Australia just announcing their scheme, established in every jurisdiction except for Queensland, including by the Morrison government in 2022 with the federal or the territories scheme. And it speaks to the fact that no political party has a monopoly on human rights. It was the Whitlam and then the Fraser governments which signed and ratified the two major human rights treaties. The Human Rights Commission was established by the Fraser government and then made permanent by the Hawke government. The Howard government, which rejected the Bringing Them Home report and regressed on human rights in a number of ways, also led landmark gun law reforms, which have made our communities safer and reduced the number of deaths from shootings. The Rudd government, which delivered the apology and set up our first national human rights framework, was also the government which 12 years ago this month set up that policy where they said no one arriving by boat who is a refugee will ever be allowed to settle in Australia. I want to end by talking about human rights and Australian values, and I hope we can continue that discussion in the panel. And Gillian, thanks for doing your work. I was looking at research on this and I didn't realise the Commission has done a paper on 100 years of Anzacs, and I was surprised to see it there and really grateful that that work was done, and I've drawn on this work in looking at Australian values. What is it that unites us as Australians? How do we define what we stand for as a nation? At Federation in 1901, Australian identity was closely linked to Britain. Racist laws and policies sought to keep Australia for the white man. The drafters of our Constitution deliberately rejected including equal rights guarantees, not wanting to give them to First Nations or non-white people. We ended up with a minimalistic constitution with very limited express human rights guarantees. On some human rights issues like workers' rights and democratic reforms, Australia has led the world, including introducing the 8-hour day, the secret ballot, women's voting rights and preferential voting. Prime Minister Billy Hughes told the British audience in 1916 that Australia was the most democratic government in the world, conveniently ignoring the disenfranchisement of First Nations peoples. During World War II, the language of rights emerged more strongly. Australia was an original signatory to the 1942 United Nations Declaration, which sought to define what the Allies were fighting for. The signatories declared, "Complete victory is essential to defend life, liberty, independence and religious freedom, and to preserve human rights and justice in their own lands as well as other lands." Australia was a leading force in the drafting the 1945 UN Charter and the 1948 Universal Declaration of Human Rights. Australia's Doc Evatt and Jessie Street pushed for stronger human rights guarantees, including an international court to enforce the rights in the Declaration. Successive Australian governments signed and ratified all the major human rights treaties. Fast forward to 2007, and it was John Howard's government which introduced the controversial citizenship test in a bid to build social cohesion around a perceived ideal of what it is to be Australian. The subsequent Labor government initiated review of the test, said it was flawed, intimidating to some and discriminatory, and it was revised, but it was kept. And it's not talked about much these days, but I like reading it. What does it say about what makes us Australian? How do we define what it is to be Australian? And the booklet says, Australians believe in shared values such as the dignity and freedom of each person, equal opportunity for men and women, and the rule of law. Australian citizenship is about living these values in everyday life. It goes on to describe other core values including freedom of speech, freedom of association, and freedom of religion. And when migrants become citizens, they must make a pledge saying, "I pledge my loyalty to Australia and its people, whose democratic beliefs I share, whose rights and liberties I respect, and whose laws I will uphold and obey." And the Prime Minister Albanese, in his election night speech in May, drew on similar themes when he said, "So let us all work together to build our national unity on the enduring foundations of fairness, equality and respect for one another." So it seems to me that human rights values are at the heart of what we say it means to be Australian. The problem is we're not properly living up to these values. While Australia supported the Universal Declaration and promised to protect the human rights set out in all those major human rights treaties that followed it, Australian people can't enforce those rights directly in Australian courts if their rights are breached. Our human rights protections are patchy and our human rights safety net has holes in it. An Australian Human Rights Act would help to address this. For me, it would be like a reverse citizenship test where Australian governments and parliaments legally promise to protect the human rights of all people in Australia. It would foster understanding and civic education by listing, I must be getting old if I'm mentioning civics education. It would foster understanding and civics education by listing in one place, protected by law, the human rights that all Australians should enjoy. An Australian Human Rights Act would help to build a culture of preventing human rights breaches. But so those human rights are taken seriously, it's critical to give people the power to take action if their rights are breached. We've already got Human Rights Acts operating effectively in the ACT, Victoria and Queensland, applying to their respective state and territory governments. And there's so many examples of the differences, big and small that these acts have made to people's lives. Stopping families from being evicted into homelessness, securing dignity and equality for people with disabilities, helping women fleeing family violence, and much more. Across the country, survey work commissioned by Amnesty and the Human Rights Law Centre has shown that support for the National Human Rights Act is strong. It grew under COVID when there was a deeper understanding of the lack of protection for human rights in this country. There's a good community campaign for a Human Rights Act with over 100 diverse organisations, First Nations, disability, faith-based agencies and more, all backing the call for a Human Rights Act. And we've had the recommendation from the Parliament's own Human Rights Committee for a Human Rights Act. An Australian Human Rights Act would translate our values into legal protections to improve people's lives. It would help make our society fairer for all, and it's time it happened. Thank you.
Thank you, Hugh. Hello, Mike. Oh, thank you so much, Hugh. That was a lot. And now we're going to try and summarise all of that. I want to introduce to you Professor Sarah Joseph, who's joining us on the panel here this morning. Sarah's a Professor of Human Rights Law now at Griffith University, but of course she was a Professor of Law at Monash University and our former Director at the Castan Centre for 15 years. Her publications focus on human rights internationally and in Australia, and with particular expertise on the ICCPR, business and human rights, trade and human rights, and a side hustle on sport and human rights, which we might get the opportunity to come into. No, it's not. That's the main one, is it? Sport. But Hugh, you traversed a huge range for us, and it was great to sort of have that come together in that way. And you raised this issue of the Federal Human Rights Act, which we have sitting on the agenda but somewhat on the back burner. And I wondered if you had reflections off speech, sort of, on the opportunities, the political opportunity that we're at the moment. And Sarah, then your reflections also on the kind of dimensions of going forward from here.
Yeah, when I started in the job, I reached out to people like Chris Sidoti to understand more of that history. And when the Australian Human Rights Commission was set up in 1986, we were meant to be set up to have a Human Rights Act that we were the national promoter for and regulator for. And there was a bill that went through the House, but never made it through the Senate. So this is something that over time, different Attorneys General have attempted to get and have failed. And you can go to the Rudd government in 2009. There was a massive national consultation led by Father Frank Brennan, an avowed fence sitter on whether or not we should have a Human Rights Act, asking people around the country what they thought about how to better protect human rights. And one of the things they recommended was a Human Rights Act, and the Rudd government didn't implement it. And now we've got the Parliamentary Joint Committee recommending it. And so why hasn't it happened? I think partly in 2009, that's our fault. When I look at the way we were talking about human rights, it was typically people like me, human rights lawyers, talking about human rights. We need less lawyers talking about human rights and more people who are affected by human rights. I say that self-consciously in a academic conference full of law students and human rights practitioners. But the messages around human rights and the need for protection has to be coming from the communities that are affected by those human rights breaches. Some of the strongest opponents to a Human Rights Act back then were the media, and that has changed So why has that changed? Why has there been CEOs of News Limited and Nine speaking in favour of a Human Rights Act? Because they have, a lot of it's about self-interest, and the Federal Police raids on the ABC and the home of Annika Smethurst helped to demonstrate for them the lack of protection of press freedom and freedom of expression. And people like Bod Carr, who was a very, very strong opponent of a Human Rights Act in 2009, has more recently come out and said he's convinced of the need for it, particularly because of national security overreach. One of the other strongest opponents was the Catholic Church. And there was a real sense of irony when I saw George Pell invoking the right to freedom of religion in about 2016 when the Royal Commission into Institutional Child Sex Abuse was arguing for mandating priests to break the confession to mandatorily report child sex abuse. So I think the landscape has changed. The people who were opposed to human rights have a greater understanding of the need for them. We saw that in COVID as well, and the time is now, and I'll be in Parliament on Monday, Tuesday next week talking to parliamentarians about the importance of this reform.
And Sarah, Sarah, your reflections on what Hugh said in the keynote, but also this issue specifically?
Is this on?
Yeah.
Okay, so you were asking about opportunities with the re-election of the Albanese government. Well, there's much more opportunities than if the opposition had been elected, because at least it's part of the ALP platform. Hugh, towards the end of his talk, mentioned I think a big opportunity was missed at the end of COVID, because that was a period of time when human rights affected everybody, and so everybody realised that human rights was relevant to them. Because unfortunately, I think part of the discussion in this country has been people thinking that, you know, human rights is not relevant to me, it's relevant to certain minorities. You know, there's always the old bugbears of it's very relevant to criminals and things like that. Whereas in COVID, everybody was affected, certainly in different ways, but everyone, you know, could recognise the relevance of human rights. Moving to the current government, they are never going to have the political capital that they have now. I don't think they can have a better majority than what they've got now, and it's almost mathematically impossible for them to lose the next election. So if they want to do it, they can, because I don't know if it's fair, but I do perceive that at least in the first term, this was a government that was quite cowed at times with regard to certain, you know, initiatives. A classic was, you know, they refused to push forward with the amendments to religious exemptions to the discrimination bill for reasons which seemed to be, well, because the opposition won't agree with it. And it's like, well, hang on, you're the government. So one would hope that that sort of timidity won't proceed. I'm probably less, like when I was a little surprised to hear Hugh just say that the media is more in favour of human rights. I think they might be in favour of select human rights, including their own human rights. And look, I'd probably even concede that the media is generally either neutral or positive, except for News Limited. I think if there was another push, or hopefully when there is another push, they will come out against it. And again, going back to timidity, the government should resist that. The last election just showed us that no one cares what News Limited think. They don't. So move forward. People especially don't care what Sky News says. And look, the final thing, I suppose, is that it will need a champion. I mean, this is getting a little bit political, but it will need a champion within the government. And I did perceive, possibly because I actually know him better, I did perceive that Mark Dreyfus was prepared to be that champion. I just don't know enough about the new Attorney General. I do know that Michelle Rowland was on the Human Rights Committee, the Parliamentary Human Rights Committee, fairly early on in its life, 2013 to 2015. But it's going to need a champion within the Cabinet. I mean, we've got Josh Burns out. I think he's outside the Cabinet. But look, there are opportunities. It doesn't seem to be a high priority because they haven't sort of mentioned it, so we have to push. And as Hugh has said, make sure it's not just lawyers and academics, but that it's a very broad base.
Yeah, it turns out no one actually wants to hear from us, but you know, who knew? Hugh mentioned the charters and human rights acts in the states and territories, and we see that as quite an important sort of push into the space. Sarah, you've done some work on sort of public reaction to the Queensland Charter and people's perception of rights in Queensland. Can you just bring some of those points out a bit so we can, that might help us understand what would be the moving parts to consider for a federal argument?
Yeah, so I'm happy to speak as the local Queenslander. So look, just, you know, how is the Charter going in Queensland? I might start with that. And look, as in Victoria, there's lots of really important quiet wins that we just don't really hear about, okay, that come from the cases, that come from what, you know, what might be happening inside the public service when it's, you know, doing things or even considering legislation, and in the Human Rights Commission's complaints function, which is really important. That is one area where, I think there's actually several areas, I won't go into them because they're a little bit technical, but I think there are a number of areas where the Queensland Human Rights Act is sort of better or an improvement upon the Victorian one, and that's not surprising because it's 10 years later. So it's, but one very big one is that there is a complaints process and a remedy process within the Commission itself, which I gather is quite effective. Look, how's it going with the government? The new Crisafulli LNP government in Queensland, it is the LNP, Liberal Nationals are together. That's not probably going so well. The very first thing it did was to abolish the Truth and Treaty Commission and Truth and Treaty process, which had only just got off the ground. And I gather they did so without even you know, letting the head of that commission know. So that's, you know, extremely rude and extremely disdainful of that whole process. Its signature policy, and I'm not kidding, this signature policy is advertised on TV ads, is the adult time for adult crime policy for kids who commit crimes. They overrode the Human Rights Act in order to do that. They also, which was a bit strange given they overrode, they did produce, I was talking with Hugh about this, they did produce a statement of compatibility, which was a great statement of incompatibility. You know, it actually admitted straight out, yep, this does not accord with human rights. Really interestingly, it's not even proportionate. It doesn't even actually keep us safer. It was hard to kind of respond apart from to go, well, yes. So, but this is the policy that is their signature policy that they're advertising on TV. Having said that, to be fair, the previous Labor government had also overrode the policy in regards to youth justice as well. There was also a review of the Human Rights Act. It was conducted by my excellent colleague, Professor Susan Harris-Rimmer, which had 70 well thought out recommendations, and the government just dismissed all of them without any reasoning. So that's at the very least a breach, you know, I think an exhibition of bad faith. They've also halted a process of consolidating anti-discrimination laws because they want to seek, you know, to have more consultation, and yet there's already been years of consultation. So, that doesn't sound so great.
Is it fun in Queensland?
Yeah, no, as I said, there's, well look, it's their first, I mean, Sue Harris-Rimmer, who I just mentioned, and myself, we did some survey work of what do Queenslanders think of human rights. And it was I mean, look, at a broad general level, they're very much in favour of human rights, and they're in favour of having a Human Rights Act, and they're positive about the, look, in the first survey, a lot of them hadn't heard of it. Many more had heard of it by 2023. We did them in 21 and 23. And they were very positive about having one, and for all those people, you know, for all those arguments about parliamentary sovereignty, they are very happy to take the government to court to enforce their human rights. You know, I guess, look, there's many things I could say about it, and, you know, I won't unless they come
Read the article.
Sorry?
Read the article.
Well, yeah, you can read the article, but I suppose a couple of things is we asked them which groups are you most concerned about when it comes to human rights, as in which groups' human rights are the most important. And overwhelmingly both times it was children. And we also asked particularly about children in care, I guess foster care or other types of care outside, you know, the family. And they were rated very, very highly. Part of that was because of a horrible case in Queensland, I think back in 2018, 2019, involving foster care. But you know, at the same time, there was very little care for youth justice or, you know, the rights of people perceived to be criminals. And so it sort of showed that, look, you care very much about, you know, these kids in a very disadvantaged situation without realising that in some certainly doesn't happen to every kid, but is often the pathway, and to issues of youth justice. And so there was a bit of a disconnect there. There were some really interesting differences between demographic groups, and one thing which is important is that I think some of the biggest and most interesting were according to wealth and levels of education. Okay, so those classic indicators of class, or what we used to call class, rather than sort of identity groups. Certainly there were differences between identity groups, but much bigger according to wealth and education. So that was interesting, and as you could expect, people with less education and less wealth were much less happy with the existing state of human rights. The final thing I could say, and look, this might come up in one of your later questions, was we asked them, we didn't ask them what's your favourite human right, we asked them what's the most important human right, and the one that came up the most was freedom of speech and or just freedom full stop. And so, and that got even stronger in 23. Now that might reflect things that happened in COVID. It might reflect Clive Palmer, but frankly in 2023 no one cared a lot about what Clive Palmer had to say, though he had freedom on a lot of ads. But that's interesting, and that's an interesting, I suppose, insight into the sorts of things people think are human rights. Housing, as you could expect, was bigger in 23 than 21, but freedom was huge. So that's an interesting, comment.
There's a lot, yeah, sure.
We were talking before just about that finding around the interest in child protection and the desire to look after kids who are in care. And the irony, obviously, is that the vast majority of kids who get into the criminal justice, there's a very close connection between child protection as a pathway into the criminal justice system. And so we need to do a better job as advocates to be explaining to the Australian public who are these children that you're asking to do adult time and that you're treating as adults. Well, they're the kids who society has failed, who need protection. And I remember going to Victoria Police Academy and seeing some of their training, and they did a fantastic thing where they de-identified a offender in police terms profile from when they were a child. And the police interactions were victim, 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 offender, victim, victim, offender, offender, victim, offender, offender, victim, offender, offender. And it just taught police that there was this, you need to have a nuanced understanding of who it is that we're locking up when they're children and prosecuting, and what we need to do as a society to actually help kids who are in trouble to get on the right path.
Thanks. I'm going to change direction a little bit. It seems like we're living in really high conflict times. It feels like there's a lot of polarisation in the debates that we're having, and there's a lot of polarisation between communities or groups in society. And I wondered, and with the referendum debate and then current issues, we've just seen a sort of quite unhinged things on social media or on different platforms that I never would have expected to see before now. I wondered if that polarisation is going to feed into or derail processes for advancing human rights protection, and particularly a Human Rights Act in Australia.
I would agree that there seems to be a lot more polarisation than, say, I remember, certainly 10 years ago or 20 years ago. Unfortunately, I think it might be a fact of life going forward. I don't see how it just disappears, that we're all going to sort of come together and kumbaya. I personally do think it seems to have, you mentioned social media, it seems to have something to do with social media and other sort of dark corners of the internet, 4chan, 8chan, 16chan, I don't know. I mean, I think it's not just social media, but it's the internet generally. I think it's problematic that people, we used to differ over opinions, now we're differing over actual facts. And you can just see that in, the MAGA movement in particular, some of the things that they say or that they seem to believe in, and what Donald Trump says every day, in terms of sort of alternative facts. And there's also echo chambers, and I think undoubtedly people have become much less tolerant of other opinions, and particularly opposing opinions. Now, having said that, first of all, social media is not going away. I don't, the genie's out of the bottle. Whether it was good to see people, ever a good idea to see people's thoughts in real time, maybe that wasn't such a good idea, but it's too late. Look, and I also genuinely think, I enjoy it myself, and I think it does have some very good benefits. I think one being it is an important check on the media itself, because I actually think when it comes to reporting things, the mainstream media is pretty poor in many ways. So, and look, just on social media, just a very quick digression. I am on record as a pretty strong opponent of, having just bagged social media, I'm a very strong opponent of the social media ban for under 16s. I think that's a breach of human rights. I think it could be a breach of the Constitution. And apart from anything else, if it works, I don't know that it will, but if it works, where that means people are not getting social media literacy, and they're getting a lot of, they're not getting social media literacy and a significant amount of internet literacy until they're 16. I think that's terrible. One thing that solves a lot of the problems from social media is actually understanding a little bit about how it works, and that it's not true just simply because, some person has said it. Polarisation is definitely problematic for human rights, because people are shouting at each other, and human rights, sometimes are very clear, but sometimes they clash, and people, have opposing human rights. Apart from anything else, people can have very different views on what human rights are. And I mentioned before, about 25% of Queenslanders in our survey, favouring freedom, whatever they meant by that, over anything else. There are very contradictory views on freedom of speech itself anyway, and we're seeing, I think, sort of quite different views of, this needs protecting, but that should be suppressed, and so and sometimes, those views seem to be sort of, hang on, not very, internally consistent. There are different human rights arguments. I mentioned before the arguments about the exemptions for religious schools in anti-discrimination law. Part of the problem there is differing views on where the actual balance of human rights lies. We're seeing that in arguments, in my view, not as prominent in Australia, but they could be coming, and we'll see in the next panel. But arguments over trans women in sport. And I think there are also a lot of very bad faith arguments out there, and many loud voices and so on. And I come back to the idea that, look, the government has to, it's certainly true they should try and bring people together and not exclude people from the debate, but at some point in time they have to move forward. It's not possible to please everybody, not in such a polarised environment. And I think, at least in its first term, the government tried to do that too much.
Thanks. Hugh?
Yeah, I agree. Polarisation is partly driven by social media, which monetises dissent and the loudest voices. We're lucky in Australia to have compulsory voting, because in the US, for example, to get people to turn out to vote, you have to be louder and more aggressive. There's a human rights thinker, Michael Ignatieff, who I've followed a bit of his work, and one thing he did was go around the world, and he did these semi-structured interviews with people in all different situations to ask them what they thought about human rights, and he was testing whether the human rights movement had been successful or not, and he, paraphrasing, came to two conclusions. One is it's been incredibly successful in saying that everyone, no matter who they are or where they are, has dignity and deserves respect. And, when I worked at the Europe Justice Commission, I saw the policies of colonial Britain in terms of treating Aboriginal people as less than human, and you look at genocide, the Holocaust, you look at slavery, eugenics. These were all things that human rights has helped to smash as a notion. Of course, there's still problems going on around the world. We've got so much more work to do, but the fundamental underpinning value is that every single person deserves respect and dignity and human rights. Why? Because they're the mere fact that we're all human. And Ignatieff said this is a major success. And even when bad things are happening, we're defining it against this standard. But then he said everyone defined their rights as a group in opposition to other groups. And this is the massive challenge that we have. We're socially hardwired to form into groups and that creates opportunities for people to exploit those divisions. And so the need for us is to find common ground, and I think human beings are naturally empathetic, and how do we find that common ground? And Brian Stevenson, who's a fantastic thinker, talks about proximity. How do you connect with someone who's a completely different life experience, who's involved in the criminal justice system in a watch house in Queensland? How does mainstream Australia understand that experience? How does mainstream Australia understand the experience of First Nations communities who are always proximate to deaths in custody and criminal justice and child removal, something with my upbringing I was so removed from? And I think a lot about, I spoke at a rural and regional conference in Port Macquarie 2 days ago, and I think a lot about the perceived conservatism of rural Australia. And then I think about the Home to Bilo campaign. And you go, here is a family, the Murugapan family, Sri Lankan people seeking asylum, whose asylum claim was rejected, but spent years in this community, raising their children in this community, and the community fought hard for them because they knew them and they had that connection and proximity and that empathy. And suddenly you have this national campaign around that family and the Prime Minister saying, we want them to stay in Australia. And it's an incredible example of what human connection and empathy and finding common ground can do. And I think that's the challenge for us in this increasingly polarised world, is to find those spaces where we can find common ground in humanity. And of course, there are those that know that, who oppose that, who try to put up the walls, the barriers, the media blackouts, the lack of access to journalists and storytellers to stop that from happening.
Thanks. I'm going to ask another question, but then I'm going to take a couple of questions from the audience. So now is the time to start thinking about your question. In another change of direction, you mentioned the Universal Periodic Review, and I mentioned it too. Sarah, you get a chance to mention it too. But these kind of review processes that happen on the international stage, Australia's going to be up in January, I think, for that Universal Periodic Review process. Australia's overdue for the range of treaty monitoring body reviews, so another series of reviews that happen in the UN space. You mentioned a few of the key kind of issues that Australia will probably have to face, but where do you think the international world and the other countries will be looking at Australia closest? And Sarah, I wonder if you can reflect on, do you think it creates domestic pressure to make the government shift further into reform or protection?
Yeah, I think the international system, it's not perfect, but it's the best we've got, and we have to invest in it. And at the moment, that system is absolutely under crisis. I was in Geneva in March, and like the feeling there is palpable because of the retreat from multilateralism, with the funding that's been stripped from the UN system, the funding that's been stripped by the US from the international aid and development system, and then other countries saying we're going to prioritise funding defence spending in Europe over aid and, for the NGO sector and those, more importantly, who benefit from the work in vaccinations, in development housing and things like that. It's a disaster. And so as a country like Australia has to invest in that system and has to support support multilateralism. Our leadership on that is needed more than ever. These systems, you get what you put into them. So it's about UPR. These recommendations aren't enforceable. There'll be recommendations from countries around the world who don't have good human rights records. You want to pay more attention to the countries that do have human rights records. I was looking at what Canada recommended to us last time. It was essentially set up a Human Rights Act, implement the UN Declaration on the Rights of Indigenous People in Australian law, and though France said do better on climate change, these are the kind of recommendations that help to shine a light on the kind of things that Australia should be doing, and the NGOs and others should be focusing on that. And Raise the Age was a big focus last time and helped to elevate that issue in national consciousness.
So To what degree do these kind of processes create pressure domestically for actual reform?
Look, in a way, I think you would know more about that than me in your current role, but also Human Rights Law Centre. I think it's incremental. I mean, as Hugh said, they're not enforceable. Australia does care. It absolutely cares what its peers say to it. It cares about what it thinks, what other countries think about it. So in a way, for Australia and for many countries, UPR, it literally is. My prediction would be that when it comes to Australia's UPR in 2026, that each country that wants to speak will have about a minute. And it's incredible what those have to, but it is incredible how many things they can say in a minute. It's actually
5 recommendations or something in 1 minute.
Yeah. Well, no, I've heard more in a minute. So, they dispense with the niceties, and that's actually quite good. So, and so that can sound like a sort of fairly superficial process. And in a way, yes. Yes, it is. But all countries care about what other countries say, and everything sort of has, a diplomatic angle to it. The recommendations will undoubtedly be shaped by NGO lobbying, as in Australian NGOs lobbying other embassies as to what they say. I think there's a very strong correlation to NGO lobbying, particularly on the ground in Geneva, close to the time, and what is said by countries to Australia. So Australia cares, but when it comes back to domestic pressure, I think, for a start, is there pressure coming from the Australian people, which is the most obvious source of pressure? It's probably not going to come from the opposition, okay? It could come a bit from the media, particularly The Guardian, which is very good on UN processes, but I don't think the other ones are. And it's quite an esoteric process. And, so, I'm not sure, I don't blame the Australian people for not knowing a lot about it. So it can help a bit. There will again be, because I don't expect we'll have a Human Rights Act by January or whenever it is, and so there will undoubtedly be lots of recommendations like the one from Canada. It's incremental though. You can't say, oh, it's the game changer, but it helps. It helps. And I know it sounds strange for me to say Australia cares, but maybe not enough to actually do something. But eventually it's sort of, all the various sources of pressure, international, it's probably not the game changer, but it helps. It helps the other sources of pressure. So, and I think, it is important. And strangely enough, like Australia seems to sort of have, in a way, a little bit more respect for UPR. It doesn't walk out of UPR kind of, that was terrible or whatever, whereas Australia, particularly under Liberal governments, has often complained about the other human rights processes, particularly ones from special rapporteurs or the UN treaty bodies. It feels safer attacking those than attacking other countries. I guess that's because of, the possible quid pro quo.
There's a lot more to say about this, but I just make one comment. It provides opportunities for action. And I remember there was an old case, Corinna Horvath, who made a complaint. So she was beaten up by police officers in this bungled raid on her house. She sued the police force and the individual officers in the Victorian Supreme Court, County Court, won. I think she was appealed. She won against the individual police officers, but the state wasn't vicariously liable for their wrongful acts. And in the normal way that an employer would be vicariously liable for the wrongful acts of the employees. And she didn't get justice. So the police officer said, well, we're bankrupt, and they never paid, and it got appealed, and it eventually got taken to the UN and the UN Human Rights Committee, and they made a recommendation that Australia compensate her for this, and it had gone nowhere for like 15 years or something like that, and then Victoria Police compensated her. And I saw Ken Lay, who was the Chief Commissioner at the time, and I said, thank you so much for doing that. Like, what was it that changed your mind? And he said, oh, I'd never seen it before. And I thought it was wrong, and it came across my desk, and I wanted to fix it. And I'm like, oh, like 15 years of work, and then one decision maker, it gets before his desk or her desk, and they say, yes, we're going to fix it. And I'm reminded of a meeting we had with Attorney General George Brandis 2 UPRs ago, and he was in Melbourne Anna Brown invited him to come to the Human Rights Law Centre offices. We've scrambled to get about 10 NGOs together, some on the phone, some present, to talk about voluntary commitments. And one of the things we said was Australia's got this reservation to CEDAW, the discrimination against for women fighting in the army and defence forces. And we said it's wrong. And he said, yeah, that sounds wrong. I'm going to change it. And he did. So we removed that reservation. And it was just those opportunities that presents. And it's hard to get before those decision makers. But what it does, it provides scrutiny, it provides opportunities, it provides pressure. And people in power, it gives them moments to do the right thing.
So I feel like the message is never, 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 never give up, because you don't know at which angle or which intervention or which opportunity or which cocktail party you end up at it's going to actually make a difference.
John Kingdon's policy windows, but on a micro level with decision makers.
Thank you. We've got a chance for some questions. So yes, here in the centre, just wait for the microphone if possible.
Gillian Moon from the Australian Human Rights Institute at UNSW. Thank you very much for your presentation, Hugh, and for the really interesting discussion. And now we all feel overwhelmed by all the work that's ahead of us. But I couldn't help noticing 1 hour into the discussion before there's one mention of climate change, and that's it. And I think that one of the sectors that certainly has the intention and probably the capability to kill a Human Rights Act proposal is Australia's fossil fuel industry. Australia, our contribution totally to annual emissions is about 4.5% of global, and that's enough for our contribution to be worsening climate extremes in Australia and measurably worsening human rights harms in Australia. So that the loop goes straight back. We send it overseas and we harm our human rights. So Hugh, can you tell us what plans the Commission has for addressing this part of Australia's activities, particularly in the light of the ICJ decision the other night, which shows that Australia is clearly acting unlawfully. It has not conducted any due diligence. It has no cap, no limit, no plan, no policy, no discussion, no regulatory framework. Those exports don't exist, yet they are causing human rights harm.
Thanks for the question. And so we're about to publish a report on the need for action on climate change, looking at it from a human rights perspective. And I think the Commission hasn't done enough work in this area. And if you go to our website, there's basically next to nothing that we say about climate change, and that's embarrassing, and that has to change. And the team's been doing good work to address that. And so we have a draft report, which I finalised reading last week, which now needs to be updated because of 4 decisions. The Inter-American Court, the Federal Court decision on Torres Strait Islanders, bad decision, the ICJ decision, and I think there was a New South Wales Court of Appeal decision. Yeah. And yeah, that's in there because it's the report. Yeah, so there was the UN Human Rights Committee decision as well. So what role does human rights advocacy have to play in this? I think the environmental movement has been doing a good job, and increasingly human rights advocates are working with the environmental movement to say this isn't just about a healthy planet, it's about the damage to people's lives. So I think we can reach different people in different ways by looking at the different perspectives that human rights advocates bring compared to others, looking at the right to education, the right to housing, the right to jobs, livelihoods that which will be affected by climate change. So we'll be doing more work on that, and it'll come out soon.
I don't have much to say. There is a panel, isn't there, later on? So yeah, so we're coming back to it, but in previous UPRs, I don't think climate change has been, or the environment generally. There's been the odd recommendation to Australia about it, but it hasn't been one of the dominant issues. I think it'll be really interesting to see if it's, if it goes way up the charts in the next one, because it probably will, especially with the impetus of these new international decisions.
4 or 6 recommendations last time, and we made sure we had it in there, but we need to elevate it. And it'll be in the UPR advocacy this time.
And look, we've got a moment for a very quick question. Yes, at the back in the maroon top. You'll just have to wait 1 second. And if you can be short. If you can be short. Expansively short.
Hi, I'm Elizabeth from Monash University, and so my quick question is this. Given that you have stated that no one wants to hear from human rights practitioners and legal academics, what is it that we can do to improve this space without generating further polarisation? Thank you.
Sorry, that's. I hope I didn't say that.
But you don't want it to be that sort of News Limited, which is what they absolutely did in 2009, say, oh, this is just a lawyer's picnic. And, taking photos of Human Rights Law Centre dinners and stuff like that as if, as if there was something wrong with having a dinner. So I'll go to you, but you're the one who said it.
I think I said.
Lawyers and academics have a critical role to play, of course, and I'll just give you an example. Like, it's a community development approach. So West Heidelberg Community Legal Centre did some work around repairs to public housing tenancies. How did they do it? They took a real community development approach where they worked with the individual tenants to form a tenancy advocacy group, and then they went to parliamentarians, and who did most of the talking? Not the lawyers, but the tenants themselves, talking in first-hand language, which is going to make a much greater impact on the decision makers. So that's the kind of work that lawyers and academics need to do to elevate the lived experiences of those people who are affected by human rights abuses and help to give them a platform to talk about the impact on them and what needs to change.
Can I just add one thing to that? And that is, I've sort of been in this game for a long time, and there's always been a feeling, it seems, that, if we do get a codified Human Rights Act, that the easier low-hanging fruit is civil and political rights. And yet people care, and this kind of follows on a bit from the example you just gave, people care so much about economic, social and cultural rights. And so we probably need more messaging in that regard to sort of, indicate to people, look, you have a real stake in this. I mean, they have a stake, of course, in freedom of speech and so on, but, people kind of know about that. They might know a little less about the right to health being a recognised human right.
Well, this is the perfect moment, and thank you, Elizabeth, for that completely unprompted question, which it was. But the perfect moment to sort of wrap up this session. But we've traversed such a great sort of landscape of issues and had these deep dives into specifics of them. I hope this generates a lot of really, really good conversations as we go out to the morning tea. I think you're staying with us for a little bit longer, Hugh, so people can pick on you individually, and Sarah, certainly people should do that too, but in a very kind and generous and considerate way. So can you join me in thanking our fantastic speakers this morning? We are now breaking for half an hour, and we will be back in and starting at 11:15, and I'd just like you to autonomously bring yourselves back at the right time. And thank you all for being such a great audience. Cheers. welcome back. Oh, hello. Hi, Mike. Welcome back, everybody. I hope everybody had a lovely opportunity at morning tea to have a break, and I'm getting a signal from here. Closer, further. Closer, further. Further. Okay. It's my pleasure to introduce Professor Paula Gerber, who's going to take us through the next panel, which is Challenges in Securing the Rights of Trans and Gender Diverse People. Thank you very much, Paula.
Thank you very much, Melissa, and thank you everyone for being here. It is an absolute thrill to be facilitating this panel, and it segues nicely into the first panel. And I was really delighted to hear you talking about the 7 recommendations for strengthening human rights in Australia, and that number 3 was develop a national human rights education action plan. So I'd just like to take a moment to share with you a story. I started my PhD after leaving Mallesons, which is where Hugh also worked, and I thought a nice segue between my career as a lawyer in the commercial world and my interest in human rights was to look at corporate responsibility for human rights. And I had been doing this for a year, and I got the opportunity to teach human rights in Kosovo not long after the NATO bombing had finished at the University of Pristina. And I prepared all my materials and I went over there, and I had assumed that students would have a basic understanding of the Universal Declaration of Human Rights, of the UN system, etc., and they didn't. And then I really berated myself. I said, why did I assume that these university students would know about human rights? I didn't learn about it at school. I didn't even learn about it in my law degree. So I came back to my PhD supervisor, Gillian Triggs, and I said, I want to change my PhD topic. I want to look at human rights education and the importance of that and the extent to which we are complying with our obligations to educate students about human rights. And I did a comparative study of the extent to which students in Melbourne secondary schools were learning about human rights compared to students in Boston secondary schools. And the reason I chose those 2 jurisdictions was because Australia has ratified the Convention on the Rights of the Child, the US hasn't. Australia does not have a Human Rights Act, the US does. Which of those 2 things, international law versus a domestic human rights act, was more influential on whether children were learning about human rights in schools? And, no surprises, the winner was a domestic human rights act. Teachers didn't feel like an obligation in the Convention on the Rights of the Child really dictated what they were teaching in schools. And another example which I always point to about the importance of human rights education is South Africa. South Africa was the first country in the world to include a prohibition on discrimination on the basis of sexual orientation in their constitution. They are the only country in Africa that allows same-sex marriage. And yet it is still one of the most dangerous places to be gay. Murders of gay people, corrective rape of lesbians is a regular occurrence in South Africa. The education, the culture, the societal attitudes did not keep up with law reform. And you need the 2. You need the law reform and you need societal attitudes to be in sync. And that's why in all the work that I do now, I spend a lot of time on awareness raising, on education, why I'm so grateful for people like James Brandis in our media and marketing department to get the message out there to the broader community so that we're not just speaking to law students or lawyers. And that's what this panel is all about today. It's about raising awareness and understanding of the human rights of trans and gender diverse people. So in the many years that I've been working in the LGBTIQ human rights space, my research and my advocacy has contributed to a number of really successful campaigns for reform. In 2015, the expungement of convictions for men who had been criminalised in the times when we had laws against same-sex sexual conduct between consenting adults. That was expunged in Victoria in 2015, and Dan Andrews was the first leader in the world to apologise to our community for those laws. And now in Tasmania, we're on the cusp of seeing compensation scheme being set up to pay compensation to the men whose lives were impacted by these laws if they were charged or convicted of offences. I've seen lesbian and single women being able to access fertility treatment. I've seen birth certificate law reform so that same-sex families can have two mothers recorded on a child's birth certificate. I've seen improvements in the way we assess the claims for asylum from LGBTIQ people, banning of conversion practices in a number of jurisdictions, some progress in overcoming the invisibility and erasure of bisexual people, and in some states a removal of religious exemptions from anti-discrimination laws and the criminalising of hate speech and vilification based on sexual orientation and gender identity. And as I've seen all this progress, I've also seen one part of the community that hasn't quite enjoyed the same degree of progress in the respect of their rights, and that's the T in the LGBTIQ acronym. And in fact, we're now seeing a winding back of hard-fought-for rights in parts of the world that I never thought we would see that, in the UK and the US, for example. So in response to this, my research has narrowed its focus now to the trans and gender diverse community, and I am delighted to have recently finished a book, Sex, Gender and Identity, Trans Rights in Australia, coming to every good bookstore near you on the 1st of September. And so a bit of a shameless plug there. But what I've realised, particularly through the marriage equality campaign, is that we can quote all the stats and the facts and figures, and that's not going to change people's minds. What changes people's minds is stories and getting to meet and know people who are different from them. As Hugh said, that proximity. So I'm really thrilled that today we have Charlie Wilson and Isabel Langley with us. I'm not going to formally introduce them too much because they are going to be telling their own stories and you're going to get to know them as young trans people, and hopefully their storytelling will help you have a greater appreciation for this community. So I'd like to invite Charlie and Isabel onto the stage, please. I will start by saying they are both Monash law students. Charlie is a law student who I met at this conference last year. And so that's testament to what a great networking opportunity this is. So please, as Melissa said earlier, take time to meet someone that you haven't met before. And Isabel is also a Monash student, but doing PPE rather than law, but we won't hold that against her. So I often get asked when I knew that I was gay. And it's a question that I really hate because there was no light bulb moment. It was just something that I always knew about myself. Do you get asked when you knew you were trans, and how do you deal with that?
Yeah, a lot. Particularly when I was younger, it was always a big topic. But for me, it was similar. There was no singular epiphany where I figured it out. I'm like, oh, I want to be trans. It was more this slow, over my childhood, build-up of discomfort with boyhood and masculinity. I despised. Every time people called me like when you're a little boy, people were like, good boy, sent a cringe down my spine. I hated the idea of growing into what I thought was a man's body, and like all of these physical changes that would come with that. It was all just a lot of feelings, really, which I spoke to my parents about constantly. I was trying to like fix it. I was a very sad kid because of those things. And after years and years of talking to them about it, I was taken to a child psychologist child psychiatrist, who introduced me to the concept of gender dysphoria, among other things. But that resonated with me a lot. And when I found out, I don't have to live like that, I'm not resigned to hate myself forever, I was really excited and happy. And yeah, I never really looked back after that.
Great. Charlie, can I ask you the same question? Can you share your journey to realising you were trans?
Mine was a bit different. I'm a Queenslander, and I grew up in quite a conservative household. So I had those early sort of feelings of not belonging, but I also have an autism diagnosis. So any of those sorts of expressions of feeling wrong in myself was very much been like, it's because you're autistic, not because, you're transgender. And so I think the first time I said that I remember being, I think about 7, and I've got a younger brother and younger sister, and identifying more with my brother than my sister, and getting really confused and upset by that. And I sort of had expressed that to my mum, and she was, wanting to be welcoming and was like, if you feel like this when you're older, but that was very much, had a lot of pushback from my dad. So every time I expressed myself in my true identity, if I cut my hair, he would get quite frustrated and upset. So for me, I sort of had to internalize a lot of stuff. So I didn't transition until I was an adult. And for me, it got to the point where I was like, it's like a massive act of self-love to transition and to know yourself so well that the whole world can't convince you otherwise of who you are. And I think that, it's every trans person has their own journey, but there are some similarities that I think we all experience. And for me, like knowing that I know who I am and that I have an inalienable sense of self is something that I, as an adult, am very proud of.
That's fantastic. And thank you both for your willingness to share really very personal stories. But this, of course, isn't the first time you've shared your story. Some of the audience might recognise you from your 2014 appearance in Four Corners. Well, not appearance, a whole episode about your transition. What was that like for an 11-year-old to have that sort of spotlight put on you?
It was weird. At the time, I really didn't care, mainly because the whole point of doing that for me was that I was feeling this very existential dread about the laws surrounding access to stage 2 treatment for trans kids at the time, which, if you don't know, is hormone therapy. And at the time, you had to go through the family court and wait till you were 16 in order to access it, which for me would mean that I would have had to eventually at least somewhat start male puberty before getting that treatment, which was terrifying to me because I didn't want a lot of the physical changes that came with that. And I was getting really frustrated with just my country, the fact that no one seemed to care, and for me it was like this felt life or death. Like I couldn't do anything else until this was fixed. So when the opportunity came up to talk about it, I was like, yes, anything that might help. And yeah, so I was far more focused on that at the time, but afterward, the attention that came from it was really surprising to me. I wasn't expecting it to be as big a deal as it was. It was quite at least in Australia, that kind of program hadn't really been run before. And I was really pleased to see the splash it made, the way that it made a lot of other kids feel seen. And it did have a real effect in changing that law. It got a lot of recognition for the issues about that, and eventually allowed me to move forward in trying to affect that kind of change. Yeah.
You must be very, very proud of that. one of the things that really struck me about the program was how much support you had from your parents. And we have a lot of research that shows that members of the LGBTIQ community are overly represented in homelessness, that they're, a lot of young LGBTIQ people fear rejection from their parents, and that fear is often well-grounded. So you mentioned a bit about your father, Charlie, but did you enjoy the same level of parental support that Isabel did?
Short answer is no. Long answer is it's been a journey. So for me, my dad and I, we don't have a particularly good relationship, but I don't think that's just trans people. I think everyone, especially members of the LGBTI community, often can have difficult relationships with their family members, but my mum is very proud to say she has 2 sons. We're very close, and she was the one who actually pointed out that it is a gift to know yourself so well. And so, but I find support in lots of other places, and you think about, you have parental love from usually 2 parents, and I might have 50% from my birth parent, but that other 50% has been filled by so many other people, and so many, I've met lots of people through community campaigning, and my partner's family, and educators, and my close friends. My best friend is a cis, straight, white man, and he's the best ally that anyone could ever ask for. So people, is rejection, and that's something that has been difficult, but there's also been so much love and empowerment, and so I think that kind of outweighs the sort of complex feelings. But families are complicated, and I don't think that's just a trans person's experience. I think that's just people.
Yeah, absolutely, and we certainly talk a lot about family of origin and family of choice, and it's great to hear that you have such a strong family of choice supporting you. A lot of the discussion that we have about trans people is access to healthcare. Now, you featured again on the ABC in the Australian Story episode with Michelle Telfer about...
Television star.
And I'm wondering if you feel that you got the gender care that you needed, gender affirming care that you needed, when you needed it, and what the transition was like for you from the Children's Hospital to adult healthcare services.
I am very, very lucky to say I do think I got the care I needed when I needed it. And honestly, I had to fight really hard to make that happen, and I was very lucky in a lot of ways. But yeah, I was 14 when the laws around stage 2 treatment were changed, which was just in time for me to start it at the appropriate time to avoid male puberty. And so I got to, basically, that wouldn't have been any different if the law had been changed 10 years prior. And I got really good treatment from the Royal Children's Hospital. They took a lot of really good care of me. They take really good care of everyone who goes through the system, although it's, I'll talk about that later, but it is very difficult to access it sometimes. But transitioning into the adult system was quite hard for me because I had spent almost 10 years at the Royal Children's Hospital. I had such a relationship with my doctors, Michelle Telfer in particular. She was my primary pediatrician. And it was hard to say goodbye because I was scared I wouldn't get the level of personal care that I got from them. I felt as though they really cared that what we were doing was best for me. They cared about what made me happy. And I was scared that I wouldn't get that from anywhere else. But luckily, moving into the adult system was relatively seamless. I've found a really good GP eventually. And yeah, I'm quite happy now with how all of that's going. Although I do miss sometimes I had a whole team at the Royal Children's. I miss the community feeling of that a little bit sometimes, but yeah.
Thank you. Charlie, you and I are both refugees from Queensland. what was it like for you moving states, starting university in a new town, and have you experienced any challenges in being recognised as a man here?
So I arrived in Victoria just after the marriage equality plebiscite. So it was after the vote, but before the announcement. So when I moved into my university dorms, the main street of Hawthorne, Glenferrie Road, was covered in rainbow flags. And for me, it was, I think the night before I left, I told one of my friends, like, for the first time, like, I think I'm transgender. And so moving, like, 2,000 kilometres away gave me an opportunity to be able to find myself. And in a place where, at a time where Victoria was quite accepting and quite proudly accepting that. So, yeah, I've been able to feel very at home and be able to grow into myself here, and I'm very grateful for my adopted state. I've been quite lucky, actually, especially in law school, to have a lot of like male friends, and I think that there's these sort of targeted hate towards trans women doesn't quite hit trans men quite as much. There's a little bit more of the, oh, they're confused girls, or, you know, there's a bit of misogyny in there, but the sort of day-to-day sort of hatred isn't there. And it's also a bit strange when you start getting a bit of male privilege. I feel like I need to sit down and be like, whoa, like, but yeah, I've been quite welcomed. There has been problems with documentation. I don't know if we want to get into that now.
Yeah, go ahead, yeah.
So I had the unfortunate opportunity of being born in New South Wales. So for those who do not know, New South Wales was the last state to change your ability to change your gender marker on your birth certificate without having a sex reassignment surgery, which isn't actually available in Australia. So for me, because I was born in New South Wales, I appear only in New South Wales Birth, Deaths and Marriages Registry. I grew up in Queensland and lived in Victoria, and I was trying to get my passport renewed. And I had this problem of not having enough identifying documentation that lined up. So I had to go through Birth, Deaths and Marriages Victoria, which allowed me, because I'd lived here for over 5 years, to say, yes, the Victorian government recognises that you're male, you may get you may change this on your driver's licence. From there, I then had to go to the federal government and ask for a specialist form to be able to, when applying for a passport, note that my birth certificate was incorrect. So DFAT had noticed that New South Wales and Western Australia, up until recently, to change your sex marker on your birth certificate in Western Australia, you had to go to the Gender Council, which is like a jury for, you had to go a bunch of people and argue that you are trans and that you should be able to have documentation that reflects that, which I think is quite crazy. So I had to, go through all these loops to just get a passport. And I wasn't able to get a director's ID to sit on a board of directors because I didn't have enough identifying documents that said I was born on this day, I was male. So I sort of was stuck in this sort of legal space. And the frustrating thing was, I don't live in New South Wales. I've never voted in New South Wales, yet I'm bound by the laws of New South Wales. And I was very happy, actually, I remember calling Paula when Alex Greenwich, an independent in the state parliament, put forward a small amendment bill called the LGBTI Amendment Act, that went through and patched up a bunch of existing laws to fall in line with the rest of the country. So changing some wording around people with HIV statuses, and for me personally, changing the Birth, Deaths and Marriages Act so it falls in line with Victoria. So now, after like a process that I started 7 years ago, I have a birth certificate. I don't have to give over 10 documents when, trying to apply for a job or a degree. So that was something that was very frustrating, and it's probably been something that, and now I have that passport, but there's also the concern of when I travel internationally with that passport, will I be respected? And I think under the current US administration, if I enter the US on a legitimate Australian passport issued by the Australian government, because it does not reflect the sex I was assigned at birth, I would be entering the US under fraudulent pretenses and could face criminal prosecution.
And we're going to be talking more about international developments in this session. Isabel, it feels like trans women in particular are increasingly being vilified and persecuted by politicians. Clive Palmer, Mark Latham, Claire Chandler, Catherine Deves, a candidate, not a politician. What impact do these sort of attacks have on you?
Well, for starters, I would hesitate to say that trans women are particularly attacked. I think it's different between trans women and trans men. I think trans men are equally bad in the sense that they are infantilized, they are treated as more confused, they are kind of erased often from discussions. Which I think is also incredibly harmful. But yes, in trans women, it does take the form of more overt vilification, treating us as, like, on the face of it, potential rapists. And it does really affect you. For me, growing up as a trans girl, particularly, I came out when I was 9. I was really like in a fairly fundamental stage of development while absorbing all of this information from the world around me. And it does it affects how you see yourself. You sort of are trying really hard to virtue signal innocence to everyone around you just so that they don't assume evil. And I think it is something that I'm able to escape relatively well on a day-to-day basis nowadays because I have the privilege to pass relatively well. But for a lot of trans women, this can lead to violence with people. It can lead to real severe mistreatment, and not just trans women either. It can affect cis women who just don't look the way that people want women to look. It is a really, it's a disgusting prejudice that I really wish people would stop touting, and I think it is just plain harmful. It's not helping anybody. Trans women are vastly more likely to be the victims of violence than to be the perpetrators, more so than almost any other type of woman. It is, it's really scary, and it can be really hard, but I do think that the more representation we have of trans women, the more trans women we see, in media, in politics, being normal people, just like anyone else, I think that will whittle away and people will see it for the transphobic, unhelpful stereotype that it is.
Yeah. You mentioned the US. I just recently returned from the United States where I attended the World Pride Human Rights Conference and spoke there, and I was very nervous going there, even as a cis person, just because I've got a bit of a profile in the LGBTIQ space, and I have written about Trump, and in the end I sailed through the immigration process, even though I landed in Texas. But one of the other keynote speakers, Lady Phil, founded Black Pride in the UK, and her ESTA, the visa waiver, was cancelled without explanation the week before the conference. So she had to give her presentation via Zoom. And it was really a stark contrast to the World Pride Human Rights Conference in Sydney 2 years earlier. That was a joyous occasion. There were flags, progress rainbow flags everywhere. Sydney Harbour Bridge was closed and a huge march across it led by our Prime Minister and our Foreign Minister. In DC, there was not one politician who showed their face at World Pride. Not even the Mayor of DC was there to welcome us. And the mood was more like a funeral. The trans community is reeling from the tsunami of laws that are targeting them. And I'm not just talking about Trump's executive orders, which are bad enough, but this year alone, there have been 953 bills before federal and state parliaments targeting trans people in one way or another. Healthcare, access to bathrooms, sports, all sorts of things. And Of course, in the UK, we also have the decision that came out from the UK Supreme Court in April for Women Scotland that has had a devastating effect on the trans community over there. So my question for you, Charlie, is what is the effect on the trans community here in Australia of these international developments?
I think, I don't know if, I'm sure Isabel has a similar opinion, but I think there was real fear, as before our federal election, that we could be going very much down the same route. And I remember opening, admit to being a Reddit user, Reddit the day after the federal election and going on to r/transgenderau and seeing people just so happy that we'd had a return of a government that doesn't want to single them out as a group that needs to be removed. But it's almost like always waiting for the other shoe to drop. Like at any moment, the laws we have that protect us could go. And I think that that's a really difficult way to live. And sometimes you look at yourself in the mirror and be like, am I really the world's worst? Like you would think about with the amount of like 900 pieces of legislation, you're like, wow, that must be a really, really harmful community. And then I'm just a law student that's trying to, pass company law this semester, and remember to do my readings. Like it's so that can sort of really affect how you see yourself. And I think being in my final year of law school, a lot of students are talking about going overseas for study or exchange, and I'm like, I don't think this is the safest place almost on earth, and there's an incredible sense of gratitude that I live here and are protected by the legislation and by incredible human rights professionals and advocates and academics, that many of which are here today. But that stuff can always slip away. I think the Victorian Parliament was doing a investigation into high demand religions, and which is something that affects a lot of people and is a human rights issue in itself. And Moira Deeming suggested that there are people hijack that to turn it into an anti-trans thing and talking about how transgenderism is a cult. And so even in our own parliament, in our own legal system, there's always a chance that stuff will pop up, and it's a difficult way to live.
You want to share your thoughts on that?
I have had the honour and horror of watching a lot of these debates in Australian parliaments firsthand throughout my teens. So I talked a bit about the changing of laws surrounding stage 2 treatment. We were actually the second last first world country to change that. And now we are one of only, I can't remember the exact number, but less than half of those first world countries have kept that. Now America is similar, where you need to go to court to get access to stage 2 treatment in a lot of states. And that's really terrifying to me, because at the time in 2017, when that got changed, I was kind of feeling like, oh, we're catching up. We were behind. We're catching up to America. I wish I was born in America. It would be so much easier. And now to see that all going backward, it makes me realize all of this progress that I watched happen and that I helped fight for most of my childhood could so easily, in a matter of months, be snapped back, which is really terrifying to me. And I think, again, similar to you with the election, the threat that a Dutton government had using trans people as a political football, the way that they were, I was really scared that that was what was going to happen, and then I'd have to move to bloody Canada or something. And it is, it's really scary. And I shudder at the idea that trans kids today might have it worse than I had it back then, and that's really scary.
Well, certainly trans kids in Queensland
yes.
do. Yes.
Very much so. And I think in America, Texas alone, I think, has over 200 laws targeting trans kids specifically. And it's really terrifying, the amount of vilification, and it is just because trans people are the decided wedge issue that a lot of conservative people overseas and here have been using for years to try and get some kind of foothold, because it's just a topic that they know a lot of people are not overly comfortable with. And it scares me to see that happening more. Even in Australia, in parliaments, I've seen conservative politicians talk about me specifically as a social contagion, and like talking about my teenage body as though it was mutilated, and really, really disgusting things. And what I want more than anything is to just always be going forward. I don't want to be going back. And I find that I think that's a really important thing to keep in mind.
And I think some two very startling statistics, but in the week leading up to the US election, 47% of all ad buy by the Trump-Vance campaign was anti-trans advertising, 47% nationwide. And in Texas, there is a bill that's not yet passed, but was proposed to make being transgender a felony. I have no
And
comment.
they seem to feel like they can debate trans people and trans kids with impunity without realising the harm that it causes. And we've got a session on the coroner's court coming up later today, but last year there was a coronial finding about the suicide of 5 trans young people. Now, if that's not evidence of the harm that othering and vilifying this community has, then I don't know what is. And I was disappointed that there wasn't more attention paid to the findings of that inquest, which was very much about the systemic discrimination and barriers to trans people living their lives. Isabel, if you could change one thing in Australia to improve the quality of life for trans women, what would it be?
At this point, I think there is just a wave of small things. I think what I would like most in Australia is for more states, particularly Queensland, to catch up, because I've been incredibly lucky throughout my entire transition, as I'm sure you've been able to tell throughout this conversation. I happen to be born in Australia, probably the best state to be trans in, and I'm really sad that doesn't apply to every Australian, and I would like that to be the case. But I think largely one of the biggest things would just be more social acceptance, more representation, more just pride, I suppose. I feel like oftentimes trans people can kind of fall under the radar a little bit, and I think that contributes to a lot of people's discomfort and the way that people vilify trans people. It's just that they don't know us, they don't see us, and I think that kind of acceptance would just make day-to-day life a lot easier for a lot of people. For me personally, I think one thing I would love is if hormones were covered by Medicare. That would be great. That's small.
Okay. No, but important. Yes, absolutely. Charlie, probably not so much in this room, but in the wider community, when we start talking about policies and regulations and laws, people's eyes can glaze over. Yet laws have a huge impact on your day-to-day life, and I think even influence you deciding to study law. So can you talk to us a bit about policies and laws that have had an impact on your life, for better or worse?
I mean, I did also just previously go on a big rant about birth test marriages, so that's been one of the really big policies that had affected my life and had just recently sort of been changed, and it was just the action of one person in the state parliament, again, that I didn't live or vote in, being like, right, this community's been, not fairly treated. So that was one of the really big ones. I'm comforted by the things that, like, we have the Equal Opportunity Act and that we have anti-discrimination legislation and they've extended anti-vilification legislation earlier this year. But there's still a bit of a disconnect between the legal framework we have and how we can use it. So I do have a point of privilege being someone who's studying law, so I know that those laws and those protections are there. But for a lot of trans people, even though we've got some decent laws, we're still seeing acts of violence. We're still seeing, people having been discriminated in healthcare, and I think that that's something that I know within the wider space of reproductive healthcare that for a lot of trans men, accessing reproductive healthcare is something that is incredibly intimidating and a space where there's a lot of discrimination. But there has been progress made in that area. There's been, I know with cervical screening, being able to self-test and stuff, and there's been, the Victorian government earlier in the year started the, I think it's the, I don't want to paraphrase, I'm just going to check. The unsaid says a lot, which is all about sort of like body language and sort of not just, because I think when we think about hate or discrimination, we think about particular phrases, and vilification of trans people can be quite creative. Often it can come across as like love, or like, if you do this and you repent and be saved. So I think for me, we've got a good legal framework. We've got some good tools, and I think the Victorian government and agencies within Victoria want to continue to ensure that trans people have good whole existences, but there's a bit of a gap between that legal framework and actually being able to use that in society and be able to help trans people be able to live whole lives.
I do find it extraordinary that so much attention is focused on trans people that we're finally going to be counted in the next census in 2026, but the best estimate at the moment is around 2% of the population are trans or gender diverse. That's a very small group to focus so much attention on. And it does also reflect on what you were saying, that a lot of people don't know a trans person, so they do like to ask questions. And so my next question to you is what's something about being trans that you wish people would stop asking or start asking instead?
Okay. There's a few. I think people feel incredibly comfortable asking questions about my body, things that they really ought to be buying me dinner first. It's frankly no one's business, and I would love for people to maybe not it's like if you wouldn't ask a cis person the question, you probably shouldn't be asking a trans person. I'm not asking you how big your dick is or if you're circumcised. Like but I think that instead people should be asking, what can I do? How can I support a trans person around me? How can I raise awareness for the issues that you're going through? How can I support you in any way I can? I think that a lot of people are really struggling, and I think that we need more allies more than anything. I don't know. I have a laundry list of little annoying questions, but I'll leave it there to save time.
Do you want to say anything about that, Charlie?
I just wish that there was a little bit more critical analysis of things that they see or that people see or read. Like the amount of times people have asked me my opinion on kids using kitty litters at school, which was, I think, an internet meme or something that had been, I believe it was actually, there was kitty litter at a school as part of a lockdown procedure for gun violence in schools, and that had then been morphed into that children are pretending to be cats, and that is the most asked thing of me. So I think sometimes just a little bit more, if you see something or read something or engage with something, just be like, is this rational? Before you then find your closest trans person to ask them about kitty litter in schools. Because that stuff is then shared on the internet, and all it does is make trans people seem to be strange or other.
I think that's an extension also of people's attempt to make us more ridiculous, is this weird attack helicopter type argument that, kids are going to start identifying as cats and then we'll have to accommodate for them in the bathroom. It's silly.
I probably can't let this session go without talking about something which I find ridiculous that we have to talk about. And again, it's a lot of the debate that we see in the media about trans and gender diverse people, and that is sport. It seems to really be an issue that is used to galvanise people against trans people. Can I get your thoughts about participation of trans people in single-sex sports?
Yeah, I think that a lot of the arguments used to, a lot of people feel really passionately about this, and I think what people are actually trying to do when they discuss banning trans women from sports or banning trans people, period, from sports, is they're just trying to create a wedge issue. It is something that a lot of people feel unsure about enough that it is a topic that they can use to then invite more transphobia, invite more transphobic ideas to otherwise, you know, not interested people. But I do think that pretty much every argument against trans people in sport is silly. There is really not that big of a biological advantage being like me, for example. I have been on hormones for how long now? 7 years. I haven't really, I don't have any real physical differences in terms of my athletic capabilities to the average cis woman. And even if I did, there are biological variations in all people that make you better and worse at certain things. It's all quite silly, and it's weird that this is the line that people are willing to draw. And it has led to some really, frankly, hilarious but also quite depressing outcomes, such as the most recent Olympics. There was a boxer, I believe, who was a cis woman, but again, because she didn't look like how people think a cis woman should look, or she had her own biological advantages just genetically, people were calling her a man, saying she shouldn't be allowed to play. I think when you start policing the bounds of what a woman can be and what she's capable of doing, it leads you down some very dark places. Yeah.
And, the idea that sport is a level playing field needs to be questioned. I had the opportunity to talk to Ian Thorpe last year, and I asked him this same question, and he said, I wear size 18 shoes. My feet are this long. My arm span is, twice of yours. I have a huge advantage over other swimmers just because of my, biology and how my physical attributes. So, to differentiate, when you started hormone treatment or what sex you were designated at birth seems to be, not perhaps the best starting point for trying to level out sports.
And I think it is really important to keep in mind that no one's making that argument in good faith. They have an ulterior motive of trying to motivate more anti-trans thinking in people. And I think also, if you really look at the data, if you look at actual trans athletes, where they're placing, they are not dominating sports. And it's and also it's just an incredibly sexist idea that I could just walk in, me and a completely untrained couch potato could just walk into a women's AFL league and use my super manly Y chromosome to beat everybody. It's silly. It's really, and I think people should be more aware of it, because I think it sounds reasonable when you first hear it, but if you really think about it, it doesn't make any real sense. Yeah.
It is incredibly insidious, though, because this is when I think a lot of these bad actors, they're like, oh, we're speaking up for women, we're standing up for women, we're protecting women. And always that happens in the back of my head. I was like, if you really cared about women, you would use this motivation to talk about, the number of women. I think it was 104 women who were killed by their current or ex-intimate partners last year in Australia. That's an issue that's protecting, that would be protecting women's safety. So it's really harmful, because we're taking a group of people that still are marginalised in a lot of ways. Women still face a lot of disadvantages in workplaces, in safety. There's genuine concerns. And then instead of acting in good faith on those concerns, they're then pivoting to then target a even more marginalised group of people, and especially another group. You're hurting more women, because then you're hurting trans women. So it's something that just doesn't make sense to me, but is incredibly insidious, because there is still a fair bit of gender inequity in our society as a whole. And I think that's where you can get people who are a little bit on the fence one side. They're like, yeah, I care about women's rights. But it's these bad actors don't actually care about women's rights.
I mean, if you look at some of the biggest voices in the anti-trans movement, particularly around women's sports, like we all love J.K. Rowling, and
Bestie.
she did not say a bloody word about the overturning of Roe v. Wade. She does not really care about women. It is interesting how these people seem to only care about protecting women when it happens to be hurting trans women.
Exactly. I think we're probably in for a bit of a rocky period in the coming weeks. I know that the Australian is publishing an article this weekend that is going to be very anti-trans. We've got the Tickle and Giggle appeal listed for hearing in the, I think this starts on the 4th of August, which is generally going to be a licence for a lot of media attacking trans women. For people in the audience who would like to be better allies for trans and gender diverse people, particularly in this time that we're in now and that's coming, what tips would you give to them? We'll start with you, Isabel.
Well, that's a big question. I would say that I think just listen to trans people, listen to what they need from you is really important, and that will vary based on the person. I think supporting them, I think a lot of the time as a trans person, at least me personally, and I know a lot of people are similar, these things happening in the background do weigh on you. If it's scary having to just continue living your life while people are talking about you this way and trying to attack your rights. And I think just sort of offering that support, remaining aware of what's happening, don't dig your head into the sand. Yeah, I think that's the best I can say at the moment.
And I might just do a follow-up question. What do you do for self-care during these times? Are you active on social media? Do you step back from that?
For me, sometimes, this goes against the advice I just gave, sometimes I do dig my head into the sand just for a day or two, just because, like, if I just need to get groceries today, I don't want to be thinking about all these awful things, and if that's what I need to do the groceries, then that's what I need to do. But I do prefer to remain aware of those kinds of things and try and do what I can, but sometimes just distraction is the best thing for it.
It's very inconsiderate of the Australian to publish it this weekend. Like, I'm in SWAT back, I have exams starting Monday, so cheers, the Australian. Yeah, it is sort of like, I'm similar with Isabel, like you want to be aware of what's happening so you don't kind of get caught out, but then it gets hard and it can weigh on you. And I think that's the thing I want people to really take away, is that we're people first. We're complicated. Not all of us are fantastic. Some of us do things that are problematic. Some of us, have incredible abilities to advocate for ourselves. Some of us don't. So we are people first. And I think that's, sometimes I know people are afraid to interact with trans people because they don't want to get things wrong or they don't want to misgender someone. And my personal take on things like, pronouns and misgendering is, if it's something that's done because you make an assumption, people make assumptions all the time, it's how our brains work, and you correct yourself when given further information, that's fantastic. If you do something because it's from a place of being malicious or trying to cause harm or discomfort, then that's when I get a bit, cheesed. So I think that's...
And you can tell.
Oh, you can definitely tell.
Like, people, if you don't have hate in your heart as you're doing it, people will see that and they'll, most trans people, I think, will be pretty forgiving.
We've got pretty tough skin, and we just want to get by.
Yeah. All right. I've dominated the questions for some time, so I'd like to now throw it out to the audience who might like to ask a question up the back corner. If you can just wait for the mic to come your way.
Thank you. I did have a question which Paula asked for me about allies and tips for actions taken by allies, but I'll shift that to family members, not just parents, but extended family members. So for both of you, Charlie and Isabel, what would your advice be regarding parenting and family members? I have a nephew who's just come out as trans, and there are various discussions in my broader family. So what should I advise my mother-in-law and relatives in terms of a supportive response?
My dad likes to tell people that I've died, which is like a strange way, but I think a lot of parents will think like I'm losing one person and gaining another. And that can be quite harmful for a child because you're still the same person, your insides match your outsides. So probably just trying to affirm that child. And there are resources available. I was recently involved with a Ida Hobbit event that was for parents, teachers, extended family members on how to best support your trans and gender diverse young person. So there are resources available. There are trans people available who have spoken on these sorts of topics. And I think I'll pass over to Isabel to continue.
Yeah, I think as supportive as my family has been, my dad did at the beginning say, actually on national television, that he mourns the boy, which did really suck to hear at the time. And that was just that. I don't think he meant that. I think it was a slip of the tongue. But I think it is important to not treat it that way. It is still the same kid. It is truly just the same. Like it doesn't change anything. I think we tie gender to personhood so much that like we think that we have to like kill off this other version of them in our heads in order to accept them as they are now, but that's just not the case. And I think with my extended family, I think the most helpful thing for me was just that, was to just continue. I didn't want anything to change. I just wanted, just refer to me a little bit differently. Thanks, moving on. It doesn't have to be a whole discussion. It can be nice sometimes, but also the amount of times I had a family member sit down to tell me that they're not going to disown me as though it was like the kindest thing in the world. I'm like, oh my God, thank you. But it's not necessary. You can just continue loving them, continue supporting them as usual. And I think that will be the most helpful. And it's important to keep that kind of stability for them when they're already going through a lot in the early stages of transition.
My auntie, my dad's sibling, she's been one of my most vocal supporters. So having these extended family members, a lot of times she'll go into bat for me and stand up for me. So, those extended family members can really play a really supportive and affirming and an incredible role, especially in that sort of early period. So thank you for looking out for your nephew.
Another question, we've got one here.
Hi, my name's Lara. When Charlie was talking earlier about documentation, really brings to mind the fact that it's our legal rights are in everyday jeopardy. It often feels like because they're conditional and patchwork. I didn't have the bad luck to be born in New South Wales, but I was born in Malaysia, and when I asked them about changing my birth certificate, I got an answer back in all caps. And even the Australian government won't accept my passport as evidence of my citizenship. The sport is one area where this discrimination is coming into light. Another place that it happens is in other types of women's spaces. Those are often set up under the Sex Discrimination Act or other legislation that supports women's spaces for advocacy, and often they're set up in ways that are trauma-informed. But some of those spaces are exclusionary of trans women. I've been excluded from spaces like that myself. And a lot of the recent legal cases have been around that. What do you think is a possible legal or other response to this recurring issue around treating trans women as part of the threat and trauma causing and being excluded from women's spaces?
As neither of them are lawyers, I might step in and say something about that. We do have the legislation in Australia that we that does protect against discrimination on the basis of gender identity. And I think some people here and some businesses here have become a bit emboldened about their right to exclude trans women. Based on the For Women Scotland decision in the UK, our law is very different. And our Sex Discrimination Act is nothing like the antiquated Equality Act in the UK. So I think it's not so much that we need law reform as we need education and we need awareness raising. And as hard as it is for people like Roxanne Tickle to be the poster child for the Tickle and Giggle case, that is performing a huge education role. The media that is paid to that case is telling people that it's not okay to exclude a trans woman on the basis that it's only women who are designated as female on their birth certificate that can be admitted. So I hope that answers your question a bit. Another...
to add on Tickle and Giggle, in the judgment, having just a sort of wider understanding of what sex and gender is, and that it's not an incredibly binary thing, it can change and evolve through time, and that we should, that there needs to be education around that, I think, as well. And I think that was a really important thing in that particular judgment.
Yes, and people understanding the difference between sex and gender. It's why I included both words in the title of my book, and the start of the book is actually just 101 explanation of what is sex and what is gender, because a lot of people use the terms interchangeably and they're certainly not.
And chromosomes aren't the only indicator. Like, I think both me and Isabel have take hormone replacement therapy. So like I'm a testosterone-driven individual. So even though I have two X chromosomes that would usually be a estrogen-driven individual, I'm a testosterone-driven individual. I have a muscle mass closer to a male. I would have an advantage against, even though I'm really, really short, I would have an advantage. So there is, it's a sort of, there's more than just, chromosomes equals this. There's a whole heap of things, and that's part of that education. And I think I just wanted something that Hugh mentioned earlier about, having the community that is affected speaking out. Also making sure that we're having more legal professionals from diverse communities. So for me, it was the Religious Discrimination Act that made me want to become a lawyer, because I could see that, my safety and my partner's ability to work where he wants to work was affected. So that's, yeah.
Charlie doesn't know this yet, but he's quoted in the book because he sent me an email that said, chromosomes are like IKEA instructions. Some people follow them slavishly and others throw them out and do their own thing. And I actually quote that in my book because I thought that's a really colourful way of capturing chromosomes are just one part of what makes us who we are.
And also, on that note, it is like, sex is far less binary than people make it out to be. I think people, they love to point out like chromosomes and sex in general as like this hard facts, like the fact of the matter is, like, someone looking at me, they're not seeing a man. Like, no one's looking at my chromosomes. It's like I'm interacting with the world in a very in a very woman way, and for lack of a better word. And I think that like medically even, a lot of things are far more like anesthesia. I need to tick woman because like my body mass distribution is more similar to a woman's. Like it's just incredibly unhelpful to see sex as like this be-all and end-all. And also, even when you are just looking at sex, intersex people exist. It is not hard and fast like people think it is.
And non-binary people also exist.
Yes.
I think it's very important to note that like I'm a binary trans man, Isabel's a binary trans woman, but there are also non-binary people who face the same and if not more discrimination and exclusion from society. So they're also an important part of the conversation. And I think they can sometimes be even more discriminated against because I think some people, they can be like, right, you started this way and went to this and started this way and go this way. Yeah, it's easier to understand, whereas I think non-binary people they faced a lot more invalidation.
Yep, absolutely. Time for one more question up the back there.
Hi, thank you very much for your insights and particularly for being so comfortable to share with us very generously about your own personal experiences. I'm just curious to get your views on this issue from a social and legal advocacy perspective, and I'm kind of a bit curious about the relationship between the LG part of the community and the T. And I'm curious, do you think that from an advocacy perspective, the trans and gender diverse community are meaningfully and sufficiently supported by the queer and the broader rainbow community, or do you feel that the trans and gender diverse people are also marginalised within these progressive spaces as well?
Great question.
There was an organisation, I think it was LGB without the T, and it was interesting to find that only 10% of that organisation were LG or B. So this sort of like severing off the T is, that's been encouraged, I think, by people who are even from outside the queer community. And I think that there is some sort of survivalism, like if, you know, your rights in, like historically we've had a lot of human rights violations, as we're talking about people being incarcerated for same-sex sexual contact, that, you know, okay, we'll just cast off this group and we'll be okay. And that's sort of like an internal fear that then other groups are really latching onto. And, you know, but if we look at the beginning of the, really the LGBTI rights movement, like Stonewall, like the first person who threw a brick was a black trans woman. So I think that in modern, you know, LGBTI rights, we can't really sever off the trans people, that they were there at the beginning. And I think that there are people from outside the community who are leveraging genuine fear from within the community to then sort of be like, right, break them off and you'll be okay. But we know that that's not going to be, it's not going to work that way.
And I think that, I think it's naive to think that they're going to be safe just because I think, as we've discussed, trans people probably hold the most tenuous spot on the LGBT acronym. It is simply, they're working backward. Like, it's not going to end at trans people. They're always finding new villains. Like, trans people, honestly, right now are in a position similar to, like, a lot of gay and lesbian people about 20 years ago. It's all, history repeats itself, and if they start working backward on our rights, they will get to them eventually. And I think that politically it is incredibly important that we stick together as a movement because we are ultimately fighting the same thing.
And they're not mutually exclusive. Like, I am a trans man, but I'm also a gay man. So that because one's about sexuality and one's about gender, there is an overlap. And sometimes you can have some exclusion within communities. So, yeah, but it's like, you know, united we stand, divided we fall.
It used to be, the acronym used to be GLBT, and in the 1990s, in recognition of the support that lesbians had given to gay men during the HIV/AIDS crisis when it was at its peak, and the nursing and care that they did, and because of all sorts of feminist principles, they said, let's put the L at the front. I would now love to see the T go at the front, because that is the group that is really being targeted now, and I think there is strength in unity, and we should really be supporting that sector of our community. Now, to wrap up before lunch, I am an educator, which means I love to assess people. So I want you all to get out your phones, please, and we are going to have a bit of a quiz. If we can move to the Kahoot screen, if you'd like to scan that QR code or go to the URL and enter the PIN, 10 quick questions about trans and gender diverse issues. And hats off to Jen being the first person to get on there, but everyone's jumping on quickly. Just a reminder to those of you or a heads up to those who may not have done a Kahoot before, it is not enough to just be right. It is also fastest finger. So you need to be quick off the mark when you know the answer to these questions. Some of them material that we've covered in our discussion today, and some others that you might just know from following the media or social media. We'll give a bit longer for a few more people to jump on, but you're all doing a great job. And I should add, there are some very good prizes for people who finish on the podium. First,
Is anyone else missing the music?
I did ask for the lack of music. We could have some quiet music. That is a very distinctive Kahoot sound, yes. All right, how many have we got on there? 93. Can we get up to 100?
No, not 90.
Last few people jump on. And we can, whilst the last ones are jumping on, we can move to the start, please. Let's hit the start button. Okay. So remember, quick and right. The first question. When was the Sex Discrimination Act amended to prohibit discrimination on the basis of gender identity? Sex Discrimination Act has been around since 1984, but when was it amended?
If you get it wrong, we'll point and laugh at you. Bad eye.
No, we want bad educator. There is such a thing as a wrong answer, but 33 only got it right. It was 2013 that we took out the binary in the sex discrimination. We got rid of just being male and female, and we added in gender identity and sex characteristics as prohibited grounds of discrimination. Okay, let's see who's at the top of our podium. Next screen, please. That's it. Congratulations, Tom. Except, let me say this, I've done quite a few Kahoots in my time, and I have never had the person who was on the podium at the start also be on the podium at the end.
Proven wrong, Tom.
Okay, next question, please. The case of Tickle and Giggle was about what? And that picture is, of course, Roxanne Tickle. Okay, a bit better this time. 39 got it right. It is about an app, Giggle for Girls, seeking to exclude Roxanne Tickle because she was a trans woman. Did our podium change? Yes, we have a new leader. Bicon, and then Darcy and Cass. Well done. Next question, please. Which state most recently enacted laws criminalising hate speech and vilification on the grounds of gender identity and others, disability, sexual orientation, but certainly gender identity was in there, happened earlier this year. .37 got it right. Victoria was the most recent jurisdiction, not the only one. Other states have this as well, but we joined them in not only criminalising but also strengthening the civil penalties. And Ro Allen, the Commissioner of the Victorian Equal Opportunity and Human Rights Commission, unfortunately couldn't be here today, but was instrumental in that legislation getting through. Okay, how's our podium looking? Oh, bit of a change. Next question. Quick, true or false? The 2026 census will include questions about sexual orientation and gender. This is going to be one where you need to be fast, and I did give you the answer in the session if you were paying attention. Hoping to see a very strong correct response here.
It was a bit of a fight, though, this particular one.
Well, look at that. Look at that. I should say, if there's 100% correct, I do a little happy dance on the stage. So I'm glad that 7 people didn't get that right. There was a bit of a wobble. You might recall that Anthony Albanese did a bit of a backtrack about the questions, but luckily it was just a wobble, and the census, in fact, is currently piloting the questions with a select sample. So well done. And what did that do to our leaderboard? Oh, no changes there. Okay, next question, please. Which state earlier this year banned new trans or gender diverse patients under 18 from accessing hormone treatment?
Oh boy, I wonder.
Again, I'm looking for a strong response, but not 100%. What?
Oh,
the colours don't match up to the map.
Oh no, the colours don't match up to the map. That's just a random picture I picked of the states. You're reading too much into it, Sarah. Okay, well done. 74 got it right. It was Queensland. The only silver lining to that is it did prompt the federal government to initiate a study to be conducted by the NHMRC, which is a very reputable body, and who have said they're going to consult widely about a nationally consistent policy on this, because we do have a postcode lottery in Australia, or the patchwork quilt, where we have what rights you have depend on which jurisdiction you live in. So it will be good for this to be uniform. All right.
It is also interesting with the 6 people who picked Western Australia, because it did, right before the Western Australian election, the opposition did float also banning gender-affirming care for trans people under the age of 18, but they were not elected.
Excellent. Thank you for that additional information. Good knowledge. What's our podium look like? Oh, things are not changing at the top, but we still have a way to go. Next question, please. Another true or false? The international body governing chess has banned trans women from competing in female-only tournaments. Is that true or false?
Yeah. See, this is important because you could knock over pieces with the Y chromosome.
Yes.
It's a fair thing to be worried about, yeah.
This is, to use Isabel's words, silly. This is how silly things have got, that the international chess body has banned trans women from competing in women-only.
And it's just plain misogyny at some point, that someone who is biologically considered female could never be someone who was assigned male.
There is one trans woman that we know of competing in chess at an international level, and she's ranked 5,246. And she's the one who has been impacted by this change in the rules. All right, let's see our leaderboard. Oh, very small change at the top. Next question, please. In which case did a UN committee find that CEDAW protects all women, including trans women? Convention on the Elimination of Discrimination, a view on an individual communication, oh, I think a few guesses in here, but 23 got it right. It's Rosanna Flamo Caldera and Sri Lanka. Rosanna is a lesbian in Sri Lanka who took a complaint to the CEDAW committee saying that the laws criminalising same-sex sexual conduct between women in Sri Lanka was a breach of CEDAW. So the case was not specifically about trans women, but the CEDAW committee took the opportunity to say this convention applies to all women, lesbian, bisexual, transgender. So a very powerful decision. A little aside about this, I did this Kahoot quiz, I saved it, and then I got a message saying that I had used inappropriate language in the quiz and it had been quarantined and I could not use it publicly. And if issue with this, I contacted the support people. I thought, who knows where to start on what has been considered inappropriate in a quiz about transgender rights. But I got a lovely message back from Bjorn, who said that the word that had triggered the quarantining was the word flamer. It was on their list of words that were inappropriate. And how I knew I was not dealing with a bot was, he said, as a member of the LGBTIQ community, I want to thank you for the work you're doing. So that was a lovely little message from Kahoot. All right, where do we end up on the leaderboard now? Oh, Bicon, I'll have to learn how to pronounce that.
Bicon is in by icon.
Ah, okay, thank you, Bicon. Okay, next question. In the US, how many bills have been introduced this year that seek to limit trans people's human rights?
Is this year to date or is this calendar year?
This is today.
Oh, okay, so it could get higher.
Okay, well done. It is 953. All those numbers, though, all those options you can find on the Trans Legislation Tracker, which is a website tracking these numbers. So 953 bills have been introduced. 647 of them have failed. They didn't pass the legislature. 120 of them have passed and 186 are still active. So it is vital that we don't have tunnel vision about Trump's executive orders and miss what is going on at the state level and also at the municipal level. The school boards, the local councils are also need to be watched closely. Okay, let's have a look at our leaderboard. Icon is still doing well, a healthy lead from Noah and Alara. Okay, next question, please. Number 9. In a recent poll, what percentage of Australians said that politicians should not politicise trans issues for political gain? This was a poll that Equality Australia procured ahead of the federal election. This was not long after the Clive Palmer front page of the Newcastle Herald paper saying, I can't even remember what it was, a terrible attack on trans people, but 86% said no, trans people should not be used as political footballs. Okay, how did we go with the leaderboard? Oh, we have a shift at the top with just, I think, one question to go. A lot of pressure. Okay, our last question. What is the name of my book on trans rights? Three of these answers are AI generated.
I was almost expecting to see shameless plug up there.
I love equality down under.
Oh, thank God, a few people got it wrong and I don't have to do a dance, but most of you got it right and hopefully you will buy the book and I can retire on the royalties. All right, would the winners like to come up, please? Oh, well, let's look at our winners first. Mr. Key Point, key step in the process. Third place, Noah, well done. Second place, Alara. And the winner, Bicon. So in a few more shameless plugs, the third prize is the book that Melissa Castan and I edited called Proof of Birth, which is all about the barriers to people, particularly Indigenous people, accessing our birth registration system. So Well done.
Thank you.
Congratulations. Second prize, a book I wrote on human rights education. Thank you.
That's what I wanted.
And first prize, the book that Melissa and I edited, Critical Perspectives on Human Rights Law in Australia, and, to top it off, a Castan Centre mug.
Thank you so much, Paula.
Thank you.
And it was Bicon.
Bicon?
Yeah.
Excellent. Thank you for humouring my desire to be a games quiz show host. Thank you. Please join me in thanking our speakers, our panellists. And please enjoy lunch, and we'll see you back after lunch. At
20 past 1. 20 past 1. We'll call you back, don't worry.
Welcome back from lunch, everyone. I hope you had a nice break, an opportunity to eat some nice food and chat and meet some new faces. My name is Scott Walker and I am the Research Fellow at the Castan Centre for Human Rights Law. Before I begin, I want to acknowledge the traditional owners of the land on which we meet, the Woiwurrung, Wurundjeri and Boonwurrung people of the Kulin Nations, and pay my respects to their elders past and present. Our third panel today is on new challenges in climate litigation and human rights. As you might have heard in the last fortnight, it's been a pretty big week for this topic, with the handing down of the Australian climate case last week and the advisory opinion of the International Court of Justice this week. So it's particularly opportune that we have convened a panel with diverse experiences and perspectives on this issue. Let me say a few words about each of our panellists. Isabel Reneke is the Executive Director and founder of the Grata Fund. The Grata Fund is a leading non-profit based in the University of New South Wales that acts as a campaigner, litigation incubator and funder for peoples and communities challenging systemic gridlocks across three key areas: human rights, climate injustice and democratic freedoms. Prior to this, Isabel has more than 10 years' experience as a director and lawyer at a number of organisations. Sister Bridget Arthur is a Brigidine sister and coordinator of the Brigidine Asylum Seekers Project. The Brigidine sisters have been engaged in education and social justice in Victoria since 1886. In 2001, Sister Bridget was a founding member of the Brigidine Asylum Seekers Project, which provides practical support for asylum seekers. Sister Bridget has also acted as a litigation guardian in a number of cases, including the Sharma case for a duty of care for the Minister for the Environment. And Professor Stephen Vaughan, who you met this morning, is Dean of the Faculty of Law at Monash University. Please welcome our panellists. Isabel, I wanted to open up with you. The Grata Fund obviously was very key in driving the Australian climate case. Tell us a bit about that case and sort of your involvement in it.
Yes, thank you. And also paying my respects to traditional owners of this land, past and present, and any Aboriginal and Torres Strait Islander people in the audience today. I don't normally get nervous, but I see Julian Triggs in the audience, so feeling like I better do a good job. You're right, we have been really closely involved in this litigation that was brought by Uncle Pabai and Uncle Paul from the top Western Islands in the Torres Strait, Saibai and Boigu, against the Australian government. And our involvement in that case is sort of the fullest vision of what we do at Grata, which is work with communities really from the early days of addressing a systemic problem like climate impacts in the Torres Strait. And working with them, connecting them with a legal team or facilitating more legal support to address the systemic challenges that they face through the courts and then beyond the courts as well. And we do that through funding, so we facilitate philanthropic funding and other funding to communities and to their legal teams. We secure pro bono support. And then we work to co-design campaign strategies with the communities that are affected to make sure that the court outcome, whatever that may be, can be leveraged through a broader theory of change to really make sure that we get the impact that communities are seeking on the ground. And that's what we've done here. The Uncle's case, it's a negligence claim in common law. It's the first time that that had been tried in Australia. And we were heartbroken by the decision. So you will know that the Uncles were unsuccessful legally, although the judge accepted that basically every factual basis submitted was correct. So we've got a very good starting point for what comes next. But, it's bittersweet. There's been a lot of disappointment and tears and grief, and I was chatting to my colleague Carly, who's in the audience earlier, that I think a moment like that, one case is not going to solve all of climate change and the problems that communities are facing, but the setbacks that you get in that moment, the disappointment you get in that moment almost like unpicks this other wound, which is this awareness of this global, as the court described it, existential threat to all of humanity that just kind of, you know, takes a moment to catch your breath again. But the factual findings were really, really strong, and I'm really hopeful because of those factual findings and the way that the judge discussed the law as it currently stands, that there's more to come.
Yeah, thank you. We'll come back to some of the what's next in a minute. Sister Bridget, I wanted to ask about your perspective that you bring to this panel. How did you get involved as a litigation guardian in the Sharma case, and what was that like?
Well, first of all, I think I got involved in being a litigation guardian, and it wasn't anything to do with the environment, but it's hard to get litigation guardians, I think. So having represented mainly, I suppose, asylum seekers in the court where the individual people didn't have the capacity to represent themselves, either they were minors or people with some kind of inability to represent themselves in court. So I did that for quite a number of asylum seeker people, but also with some young Indigenous, mainly young, a couple not, Indigenous people who for the same reason needed a litigation guardian. And then I think the firm that was searching around to see if they could take the case with the young people, 8 young people who wanted to take this case against the Environment Minister to court. Then they were searching around and probably Googled and probably came up with my name and approached me. So I think that's how I got into it.
And what was that process like, sort of day to day during the case? How did that sort of role function for you? And what was your motivation in doing that work, other than just need, I suppose?
Yeah, day to day, it was, I suppose, in one way, hands off, but in another way, because as a litigation guardian, you have to actually instruct the lawyers. So I couldn't afford to be, and they didn't let me, be too far removed from it. So we would have regular Zoom meetings and so on, mainly in that kind of medium, which is how everybody seems to meet these days. They were a great team of lawyers and the kids were amazing. So we'd sometimes have different subsets, sometimes the lawyers just meeting, but often the young people themselves who were really keen to be educated and who indeed were very savvy and knew a lot of stuff in any case. So it was, over the time, there was a fair bit of talking and, making decisions about what next and,
Thank you. Stephen, you bring a perspective on lawyers' ethics and a background sort of environmental regulation to this discussion. What are the sorts of ethical consideration that lawyers have in sort of bringing these types of cases?
Thank you. I started my life as an environmental lawyer, so I was in practice 10 years doing environmental law work. I did my PhD in chemicals regulation. If you're an environmental lawyer, you know that's the sexiest part of environmental law. And then a chance conversation with a legal ethicist got me interested in lawyers' ethics. And so for many years I was researching 50% environmental law, 50% lawyers' ethics. And then a paper came out by Natasha Affolter on the hidden persons in environmental law. And the point she was making is that we often focus on judges or policymakers, and there are other groups we might want to get interested in. And so I started looking at, initially, lawyers in large law firms, the sort of lawyer that I was, and their role in relation to climate change. So I acted for BP and BAE Systems, and the line was always, if it's legal, then it's fine. And I was like, I don't believe that. I don't believe that as a starting point. It's not sufficient for me as a premise. And so a lot of my work, what Isabel said earlier, one of my first papers is called Existential Ethics. What does it mean to be a lawyer in those very large law firms where you know that the work you are doing has these very significant consequences? Is it okay? Is it sufficient just to say, I'm not a legislator, the law allows me? And then because I'm very equal opportunities, I've moved on now to critique in-house lawyers, NGO lawyers, movement lawyers, basically everybody. And The questions that I'm asking is, lawyers are products and agents and servants of the rule of law. What does that mean in relation to climate cases? What does it mean for your independence? What does it mean for your integrity? What does it mean for acting in a client's best interest, et cetera, et cetera? And all I ever want to do, well, two things. One, if I make lawyers feel a little bit uncomfortable, I'm quite pleased about that. And second, I want to encourage a conversation, because these things just aren't talked about as much as they should be.
Isabel, you mentioned a moment ago about sort of next steps, and in the Australian climate case, Justice Wigney, as you said, made many findings of facts were in your favour, but mentioned sort of the unsuitability of the vehicle of negligence of this sort of case, and the fact that Australian law hasn't yet caught up to the justice needs. What is next?
Yes, it's an interesting one. So there are a few parts to this. On the one hand, I don't agree with Justice Wigney that the common law is not a suitable vehicle for dealing with an existential threat to all of humanity. But I understand the pressures that exist within our judicial system that led to him making that sort of a finding. And that's something I really want to draw attention to here. I think just on the common law point, of course the common law evolves. What is Mabo? What happened before Mabo? Gove. Less known, stepping stone to Mabo. The uncle's case may not be the climate Mabo, but it has certainly created the stepping stones to it, and it's coming. The issue that is sort of and that's something that will keep coming through, potentially through an appeal, which they're very much looking at with their legal team at the moment, at Fifi and McDonald, and at the Victorian Bar, but also other cases as well, including, we got messages, in the days following the decision from lawyers all over the country basically saying, the factual findings in this are going to be really helpful for us in this one. Thank you very much. That's great. So we know that it's already shifting what's happening at a court level. But in terms of kind of the next big piece, that's still to be worked out. But I'm completely confident that that is a matter of time. The thing that I think is really important, particularly for this audience, that I would love to draw people's attention to is something that I think everybody here would agree with, which is that the court has a judicial lane which it needs to stick to. And in this judgment, Justice Wigney said, this would be beyond the judicial lane. This isn't justiciable. It's a matter of high policy. And I would argue what has become considered a matter of non-justiciable high policy has shifted over the past 30 years, and that's been a shift that has come with intention behind it. So if finding that land rights predated colonisation isn't a matter of high policy, I don't know what is. So I think there's been a shift, right? And what I wonder is what has caused that shift, and it's actually pretty clear and not particularly hidden, including through books like that of Tanya Joseph called The Campaign Against the Courts, including in a book I put out with Monash in the National Interest Series, that really looks at the efforts of groups like the Sir Samuel Griffith Society, which was established immediately after Mabo and Wick to deal with the risk that decision was posing to their to mining and pastoral interests and to land interests. And that campaign has been very, very effective, and I would say has not kept the court in a judicial lane, it has narrowed what the judicial lane means. And I think you see that in a whole range of areas, not just climate. You see it in protest rights decisions, you see it in warrants for raids decisions. So thinking about Annika Smethurst, effectively the AFP were told, no, you shouldn't have done that, but it was because of this technical issue with your warrant, and AFP then put out a press release saying, it was actually just a technical warrant issue, it wasn't really a problem for our democracy. ABC losing its case for that it should have had protection against the AFP raiding it over its war crimes reporting. And, even Professor Adrienne Stone, who's extraordinarily eminent constitutional lawyer, really, she plays things straight down the line on what the law says. She even in comments at the 30-year anniversary of the ACTV decision, the implied freedom of political communication decision, which is what is at play in these protest rights and journalistic freedom cases, said that the constitutional approach to decision-making in Australia has become extremely brittle, leaving it open to problems. And she said, if you had told me 30 years ago that Roe v. Wade would have been undone, I wouldn't have believed you, and I see the same pathway being possible here for implied freedom of political communication. At the same time, Simon Stewart, who was the final appointment under Christian Porter in the former government, has consistently, in decisions related to the implied freedom, called into question 30 years of precedent and said that he doesn't think it actually exists. There is an atmosphere that has narrowed the judicial lane, and we have to call it out, because if we don't, the judiciary itself could lose its own legitimacy. And I have one just final point to say on this. There was an excellent speech given in 2017 by one of the founders and judges of the South African Constitutional Court, Edwin Cameron, in 2017 at the High Court, where he essentially said, if you guys keep doing law the way you're doing it, you're going to undermine your own legitimacy and see yourselves in the position that the South African courts that allowed apartheid found themselves in, which was needing to take them down and start again. That's a big, big thing for someone like that to say. And my real hope, and I think climate change is a perfect example of this, is that we get to a place in Australia where we can enable our courts and our judges to hold their democratic role fully. We do not have courts to settle divorces and for criminalising people. We have courts to hold up the rule of law, and we've got to make space for them to do that, because they can't defend themselves in the public arena. That's our job. We've got to do that.
Stephen, I wonder if you have any reflections on that, on the sort of role of lawyers in pushing back the sort of narrowing of the judiciary's functions, how academics engage in that space too.
I think the choices that lawyers make in this space are really fascinating. There's a wonderful book by Nathaniel Frank called Awakening, which is the story of lawyers and the fight for equal marriage in the US. There's nothing to do with climate change. But what the book shows you, a very careful sort of empirical investigation, is lawyers sort of fighting with each other. They all wanted to be the ones to bring the case that eventually got to the Supreme Court. It also shows you how complex decisions were made about forum and jurisdiction and claimant. This couple is too ugly for the press. This couple is too open, and their sex lives won't let us get to where we want to be. And so I've always kind of wanted to kind of get into that with climate litigation and climate litigants and climate lawyers. There's a lovely phrase that Kim Bua and Joanna Setzer have about climate litigation and its ability to fail with benefits, connected to what Isabel was just saying. Judges have an interesting job, don't they? Maybe that's all I can say as Dean of a law faculty, but there is something about lawyers and judges recognising, which they do every day, their special place in relation to the rule of law, the administration of justice. And that then plays in with decisions about the sorts of cases lawyers bring. There was the Client Earth case against Shell in the UK under the Companies Act. Every company lawyer in the UK said, this will never win. They just cannot win. And then the case did not win. The question for me then is that a stepping stone? And in the future it will kind of be referred to, some of the comments in the case will be referred to. But the judge in that case reflected quite seriously on whether the lawyers had brought the case in good faith. Was this a good faith piece of litigation, or was it a waste of the court's time? But how do we set that against our knowledge that certain cases, certain issues need this case and that case, this jurisdiction, that type of claim? You look globally at climate litigation, you think about the UK, think about France and other places, you know that judicial review and Paris Agreement cases tend to fail. They almost tend to fail. Does that mean lawyers should stop pursuing them? Or does that mean you just have to wait for the one case that gets through? What does it mean when cases lead to bad precedent? How harmful is that? And again, all I'm wanting, in a very academic way, sadly, is to open up these questions, not to give any answers, that's not my job, but simply to open up the debate and to gently push the lawyers to say, are you competing with each other? How strategic are you with your strategic litigation?
Thank you. Sister Bridget, I want to zoom out a bit from the lawyers and talk about your time sort of advocating in the community for various issues. What have you learned from your time doing that in terms of how to push causes into the public arena effectively?
I think my first response is that even though issues seem to be really different, with a whole lot of different reasons for looking for change, there's also a lot of similarities between the big areas of contention, I suppose, in our society And often the answers, I don't know the answers either, but the answers lie in the culture of a country, the dominant culture, rather than, at first sight at any rate, just in that specific arena. So things like how much can we generate a belief in our country about the common good rather than individualism? What sort of approaches do we take to nationalism, where borders begin to be very much keeping out those who haven't got as much as we have so that they won't take what we've got? Or that we're better than the people on the other side of the border in another country or whatever, rather than we're talking about human beings here, and also beyond that we're talking about a globe that's either going, a planet that's either going to survive or not. So what are the commonalities that we in a democratic society think we believe in, and when it comes to the test, what do we actually do in the face of many of these big issues? And I think in order to go down what I think, at any rate, probably all of you think is the right way, we need good dialogue, we need good leadership, we need to move from can we get more and more and more for us as a country and more for us as individuals, to what can we do? What can we do to move forward as a total society? Things like, do we debate at all or bring up much for consideration? Things like, enough is enough for all of us? Or is it a better world because we keep striving to get more and more for those who already have a lot at the expense of less and less for those who don't? I suppose I'm going beyond what, but it certainly strikes me that Australia on the whole has, I think, decent people. People I meet at any rate, when I meet them face to face, I think most of them are decent. And that if we had good leadership and good debate and good dialogue, we would continue maybe to refine a bit more where we are. And then certain things would be taken for granted, so that, when something comes up and it's definitely going to be at the expense of a certain group of people, there would be a light bulb sort of for most people that says, hey, let's not go down that path. These particular people are going to be disadvantaged, hurt. And then we'd start self-correcting. I might stop there.
Yeah, thank you. Stephen, I wonder what roles law schools play in developing the common good, in allowing, in training the next generation of lawyers to think about these issues in much more expansive terms.
I think we're probably already pretty much perfect on... No, we're not. Sorry, that was a joke. The deans get to have lunch twice a year with the Vice-Chancellor, and we are generally asked one question, which is, what's keeping you up at night? And when we had the one in February and March, I said, I'm struggling to understand the role of universities as social institutions, and what our obligations are in relation to our moral courage. When should we be speaking up, on what issues, in what ways, how do we use our expertise in the public interest? And that translates down into what my job is and what the job of other deans of law schools, what they have to do. Law schools are generally very conservative, and what I mean by that is we like path dependency. So we teach contract and tort and crime, and we teach them in blocks, we do it in certain sorts of ways. We don't really have to do that. Even when we have relatively strict rules on accreditation, we don't have to teach something called tort. So I had a conversation with a colleague who's a climate litigation expert, and I was like, gosh, your research is phenomenal. I love what you do. And you also teach tours. I'm guessing that you bring this phenomenal expertise and, you know, showcase that to our students in taught. Oh, you don't? Why is that? Well, can I? Yes. And I think part of my job, part of the job of a law dean, is to give permission, to say, go and give it a go. You know, like whether it's climate change, whatever else it might be, bring that into the way in which we teach. There's a bit of a debate we're having at Monash, and I'm on one side, which is about whether we are there to create a safe environment for our students or another type of environment. And I'm pushing back on safety. And it's not that I don't want our students to be respected, to be protected from certain forms of harm, but I think our job is to offer places of challenge, respectful challenge, to say to them, these are the complexities of the world. These are the issues that are going on at the moment. I'm not going to hide away from them, and I'm not going to harm you, but I'm going to kind of bring these to the forefront and have the conversation. Now, that's very easy for me to do like this. The hard work, my colleagues in the room will make done over the next 12 months, and thank you to all of you.
Isabel, on the theme of challenging things, what impact do you think a Human Rights Act might have made to the Australian climate case? Or what impact do you think a Human Rights Act might make more generally in this space?
So this case didn't have a human rights frame on it because we don't have a Human Rights Act. So we could have had a different case. Different communities could have brought it. One of the reasons that the uncles had a strong case, a legally strong case despite the outcome, is because of something called the Torres Strait Treaty. And that Torres Strait Treaty, the Australian government signed, saying decades ago, over 50 years ago, saying, or about 50 years ago, saying that it would protect the land, environment, culture of the Torres Strait, and took on responsibility for doing that. So that's where the duty was, partly what the duty was argued to be hinged on, and that wasn't a part of the case that was kind of fatal. And also, we just got to wait and see what happens with an appeal. But this case could have come in a different way, much sooner if we'd had a Human Rights Act. A whole bunch of stuff that's happening right now wouldn't be happening if we had a Human Rights Act. There would be a whole bunch more opportunity. I feel at the same time that it's really important that we have this conversation about the judicial lane and the judicial role, because there is a risk that even with a Human Rights Act, with a self-censoring judicial, self-limiting judicial role, you know, we've got to be judicial lane, just to make it really clear. I'm not suggesting anything otherwise, but we really need to create a space where the court could comfortably make decisions in line with the Human Rights Act, and I don't actually think that that's culturally true at the moment. And I don't even think it's true of the culture necessarily in parts of the bar in the way that people consider the way that the law should operate. So that's one part of the human rights piece. The thing that is also important about the human rights piece is looking up to the International Court of Justice decision, which came down the night before last, which is phenomenal, a phenomenal decision, and it makes it very clear that Australia could be sued by other states for reparations for its failures on climate change. And there's just something I want to say about that, just with the next couple of weeks, what's happening in Canberra, something that I really think is an important piece for people to be across. The government is about to announce its climate pollution reduction target for 2035. That's called a Nationally Determined Contribution, NDC. So if you see NDC, that's what that means. It's climate pollution reduction target. And the ICJ is really clear. You have to hit 1.5 degrees of warming as your maximum. That is your legal obligation. Not 2 degrees, not these other kind of numbers. And those numbers sound small, but you're talking about billions of people and the differences between them. But what's really clear from the ICJ is you have to hit 0 by 2035 at a minimum. What we're hearing is that the government is looking at somewhere more in kind of the 60s, a 60% reduction, not a 100% reduction. That will have consequences. Legally, that will have consequences. It will mean the Australian government and the Australian country and us as people will be liable for reparations to other countries. So it's something that we really need to be paying attention to. And, you know, I urge you, if you have any opportunity to talk about this publicly, to really focus attention on that net zero by 2035 is actually what the law says and it's what the science says. The Academy of Sciences says that's what we need. The Climate Council says it's what we need. It's what was accepted by the court in Uncle Pabai's and Uncle Paul's case. It was what accepted by the court in the ICJ AO. So that's something, a really important piece of context that I would love for us to be paying attention to as a community who cares about human rights. And You know, you talk to the communities in the Torres Strait, like this is the difference between them losing their homelands or not. You know, we've already got kids on these islands. They are walking to school in knee-deep water. These are Australian schools, Australian kids going to Australian schools in knee-deep water at king tides. It is an absolutely horrifying situation. And the difference in these numbers, it sounds sort of technical, but the difference is, do they have homelands or not? And as Auntie Rose, senior Saibai elder, said after the decision, she spoke directly, and she said to Chris Bowen, who she knows and has known for a long time because she's been a long time climate advocate, she said, you come and sit here and tell these kids that they're going to be moving off their homelands in 30 years. You have that conversation with them. They're really powerful advocates on the ground and in climate litigation. Often it's the First Nations people in Australia who are on the front lines because they are the people who are being affected first.
I do want to move to audience questions in a moment, so please be thinking about your questions and have them ready. Sister Bridget, I wonder what sort of strategies you might suggest for somebody who wants to get involved in more sort of community activism, who's trying to support, say, people on the front line of climate change, to advocate for, you know, more ambitious action by the government to address emissions. What would you suggest from your experience? You've spoken already about a sort of personal connection.
Over and beyond personal, yeah. I mean, that is the first stage, I suppose, is the personal. It's hard to advocate for everyone else and the whole country if we're not doing anything personally. I remember seeing a video at one stage where cleverly the designer of the program showed all of these coffee cups, and there were so many coffee cups that got bigger and bigger and bigger, you know, and showed that we were drowning just about in coffee cups. And I think it was at the beginning of my sort of thinking, what should I be doing, because I'm not doing much. So I decided then and there not to buy another coffee cup. And it seems a terribly small thing to do, but it's the one thing that I can claim that I probably haven't done since that day. So the personal is important. But I think our whole thinking about overconsumption everywhere and just bringing things up for debate, I think I said that before, but I do think that what we talk about and what gets shown on our televisions and so on, that education part of where we move is terribly important. We've had some success more in the, not in the asylum, in the area of climate justice, but more for asylum seekers, because that's where I work day by day. And, you know, MPs don't tend to want to know anything about asylum seekers because they're a bit of a problem. They don't know what to do with them. And if they don't get talked about and they kind of go away, that's the best thing that they can hope for. I'm not speaking about every member of parliament, but a fair number. So just plaguing them, just writing letters to them, turning up at their offices, urging other people to go in and say, look, I don't know much about this, but I met some asylum seekers and look, their situation's dire. Do you really know how they're living and the level of insecurity they've got and how unfair it all is and so on? Just go and talk to your local member and they'll get sick of you, particularly if you get your friends in, they'll bring it up somewhere. So I think that's the same with every major issue. Education, I have said, the consciousness that we can build about each of these major issues, in particular climate. I mean, we don't have to know a lot to know that if we don't do something, the future is terrible. You know, that, and most people can understand something about CO2 emissions and so on, even if they're not scientists and so on. And I think that the whole thing about relationships, that one thing affects another, affects another, affects another. I think justice on the whole is about right relationships. And so we've got to get relationships right, not just in one area, but in lots of others, yeah.
Thank you. I wonder if anyone in the audience might have some questions.
Hi, I'm Carly Goldstone from the Australian Human Rights Commission, and I was wondering what impact will the ICJ case have on domestic cases here and possibly an effect on future legislative reform?
So in terms of litigation, obviously it's not a binding judgment. I think we've got to figure out how it's going to affect things. I think part of it is, you know, I always think of that line in The Castle, it's Mabo, it's the vibe. And the vibe matters, I think, more than we like to admit. One of the things, you know, it was interesting hearing you talk about the marriage equality decision in the Supreme Court in the US. You know, another really great book is by David Cole, who was and maybe still the legal director of the ACLU, called Engines of Liberty. And in that he talks about, and you know, the American legal context is obviously different, but he talks about really interestingly how basically the same legal argument was prosecuted for a while and not, the legal argument didn't really change over the decades. The zeitgeist changed of what the court felt was sort of possible and in alignment with its remit. And so I think that's sort of that diffuse impact of the ICJ. I understand that opinions are being sought locally from barristers you know, across the country at the moment about the potential implications for, you know, next steps for particularly resourcing projects, so that sort of level of decision making. I'm hopeful that it will have an influence to put pressure on the Australian government to be more in line with what is required by science, because that is now very definitively what is required by the ICJ. And as I say, what that would mean, which I don't think anyone is expecting, but that would be a net zero emissions reduction target by 2035 announced in a couple of weeks. I don't think that's what we're going to get, but I think that, and I'm hopeful that it will help put pressure on, that that's the direction that we need to go. I think the Pacific Island states are also going to be using it as leverage, because, well, they've said that they are going to be, and that is obvious why they need to do that as well, because they now have actually got a litigation pathway directly against the Australian government for their failures.
A few years ago, I was in charge of an environmental law and governance master's program where we'd have drinks for all these students, and Rocky Hill had just come out, and I'd read all, 27 million pages of it. And I was talking to the students, and I said, this case has come out in Australia, New South Wales, and it goes on and on and on and on and on. Gosh, and kind of the judge is going on, and Brian Preston, what's he doing? Then I walk away, and my colleague says, oh, did you meet Brian's daughter? And I said, who's Brian's daughter? Rebecca Preston, you were talking to about that case. That was slightly embarrassing. But my point is, in that case, you think that Justice Preston is going in one direction. There's a lot about the Paris Agreement and international obligations, and there's a lot of kind of reflection on those commitments, international commitments, and the case is decided on a technicality over here, on amenity value, I think. Even when things like this advisory opinion are not binding, there is that level of judicial discretion to speak to other things. And Justice Preston, what I like about his extrajudicial writing, talks about the judicial environmental literacy that is needed in the judiciary, and I'm kind of curious about the extent to which this opinion will be referenced, not where it's needed to be referenced, but where judges have agency to make that reference.
I completely agree, and I feel the same way about the factual findings in the Pabay versus the Commonwealth case. And the point around judicial understanding, even, senior barrister level understanding of the climate science, like I have been quite surprised by the gap, in the literacy gap there. I had at one point I thought, maybe we just need to send everyone Joelle Gurgis's Australian climate scientists book so that we can just have a good starting point, because I think what people perceive as possible in the law radically shifts, especially in the common law, radically shifts when they actually understand the detail of the science. And so that is actually a big piece of the puzzle.
I think there's a question there in the middle to the back in the red blazer. No, it's fine.
I'm Natasha Yacoub from the Caldor Centre for Refugee Law at UNSW. I thought the presenters all tied in really nicely with each other, and my question also is to all of you, I guess. And that's about the question of transnational judicial dialogue. I just finished with a couple of people in this room, actually, a book on strategic litigation in refugee cases, and we were looking at, or for the chapter that I was working on gender, was the impact of decisions in other national jurisdictions on courts in Australia. So that was under Kirby, like the case that I was looking at. So it was a particular set of circumstances with the judiciary, of course, as you mentioned, but the impact of decisions in other places was key, I think, to the other judges coming along with that, and also tied in well with advocacy, so with people understanding the issues because of what was going on internationally as well. So it was really more of a transnational discussion or dialogue between judges in a way. And I wonder to what extent where, if strategic litigation is not necessarily strategic within a domestic context because of competition, to what extent transnational judicial dialogue might be taking place already, or might be an answer to that, or useful in this context, useless.
I think it's really important, and it's definitely, I think actually even like international private arbitration is really interesting and important on climate stuff, on climate litigation particularly. And because Australia, I would say, is slower generally to evolve from that common law point of view, like looking at causation, for example, or complex causation. I had a conversation with a very senior Australian judge, recently-ish retired, who said to me that their view on causation, complex causation in relation to climate change, had shifted since being at an international conference of jurists, where they started to connect the dots between the other ways of thinking to their own. So to me, it's a really important part of the puzzle, because people, obviously, you listen to your peers, like, who am I to tell a judge like what they should be thinking, right? But if their peers are really grappling with these new problems, these are new problems that the law hasn't confronted, and it's going to have to confront it in lots of ways, talking about forever chemicals, PFAS, microplastics. There's a whole bunch of complex causation stuff that is coming through the pipeline, not just on climate, and that conversation is really essential. And one of the things I'm trying to figure out is how to make more of it happen. So yeah, completely agree.
It's not, but it should be.
This might not be around the same, answering that same point, but one that it's prompted me to think about is in the area of refugees, asylum seekers, people being displaced and moving. How much we should be learning from each other across different countries, and there's a group at the moment working on, almost finished, fairly significant paper, well, we think it is, on the regularisation of visas here in Australia. And as part of doing that, we looked at lots of the academics in particular in the group did this, but the rest of us sort of hung around and listened to what they were coming up with. What different people, different countries have done in terms of both law, practice, policies, regulations and so on. And, learning from what in my mind they got away with in terms of good laws, good policies, and then the results of that, and trying to see what's applicable from one country to another. I'm not sure whether we do enough of that. I'm not in the legal field enough, or I'm not in it at all. But it seemed to me from that exercise that we could do a lot more in terms of comparative studies in the area that I know something about, and trying to get the best of what's happening everywhere, and trying to get some agreement, I suppose, on what is the best, and then doing it in different places. But that would be a big move forward.
I think there's a question in the middle, or just there, in the dark grey blazer. Yeah.
Yes, thank you for your time today. It's been really interesting. Tanya Murphy from the Australian Human Rights Commission. This is probably one for you, Isabel, but happy for any of the panel to take it.
Could you just speak up slightly if you don't mind?
Sorry, I was really interested in the moving towards the zero-based emissions and the fact that we seem to be lagging behind and not making that commitment to do so. Where do you see the state-based regulators and federal regulators having a part in this, obviously to try and meet this target when the government may not be doing so?
Thank you. There's a massively important role, and that is in regulating generally companies. And part of the challenge is to make sure that we've got precedents that makes it as easy as possible for regulators to do their job. It's really hard for regulators to take really high risk litigation against major corporations. It's really expensive, it doesn't look good. And so for me, it's about thinking through and encouraging litigation where it can, that can set precedents that regulators can then follow. And so we've seen that recently. ASIC and ACCC both, I think ASIC has launched proceedings and the ACCC has made some statements which effectively would have been very difficult for them to do if it wasn't for some of the work and the heavy lifting that's being done by civil society. So, for example, the Parents for Climate Action litigation against Energy Australia around offsets, and that being bullshit, really, just to call a spade a spade. And, they didn't win the precedent, but they won the settlement that effectively gave them what they needed. And so, to me, we need to create pathways for regulators to do their job. It would also be nice if regulators were able to take the settings that enabled them to push the law themselves, but that's just not where we're at right now. But yeah, definitely there's a focus on the corporations who are producing these fossil fuels and lying to us in the process, because that is what's happening. It sounds maybe a bit dramatic to use that language, but if you at its simplest terms, that's what's going on.
The only other thing I'd add is we had a great event at Monash 2 weeks ago on COP and the potential for the Conference of the Parties under the UNFCCC to come to Australia and the Pacific for COP31. And one of my former PhD students, Montse Madariaga, she's Chilean, and she looked in her PhD at the COP that was meant to take place in Chile but then moved to Spain because of social unrest. And the whole point of her PhD was COP as a moment of potential, a moment of hope, a moment of action. And so as we're thinking about, what's happening here, what might be said in terms of goals and targets, if it is decided that COP comes here, a lens, a spotlight will be shone on Australia, and if it's in Adelaide, on South Australia, and what are we doing? And what you see in lots of other countries where COP has taken place, not everywhere, it's not universal, is politicians and state-based actors and mayors of cities and local authorities and others stepping up their game because there is just much greater international attention. So, we might, I'm generally pessimistic, but we might see something there as well.
Hello, I'm Charlie. I think everyone knows who I am now. I was wondering about the judicial, narrowing of that lane. It seems like it's something that is done by the legislative branch kind of on purpose. If we look at things like your mandatory minimums and then all the discourse that came around the NZYQ and how dare the court do that when it was clearly just following the law. How does the judiciary push back? And I think we're seeing an erosion in the countries like the US where they haven't been able to push back, and it's very dramatic.
It's hard. They can't. Their job is to not make public comment on these sorts of things. Justice Kirby has a bit since his retirement from the High Court, but it's really tricky, and that's why I really feel like there is a really important role for civil society. It's non-profit organisations, it's media entities that are pushing it the other agenda, and so it kind of falls back on civil society and communities to push back in the other direction. But to your point about legislative moves to make it more difficult to reach the judiciary. That's absolutely true. We're seeing that in Queensland, the Northern Territory. We saw it recently around Tasmanian fisheries at the federal level. Attempts to basically follow the well-worn path of the migration system and make it really difficult to get review from the judiciary. So that's a pattern that is definitely emerging around the country, and I think it's something that we've got to, that's a very specific example of something that we've got to push back on and say, like, actually, I'm sorry, it's unacceptable for government to just say, nah, we can't have a judge look at these things just because we don't want them to. And then in terms of that, you know, that much broader cultural push, you know, you have a major decision come out of the High Court, something like Unipingu or Love and Tom's. Where you hear about it? You hear about it in Janet Albrist's column in The Australian. You hear about it on the front page for weeks. Where don't you hear about it? Anywhere else. And that has an impact in terms of the kind of the colour of the water that the fish are swimming in, I suppose.
Yeah, I hope this is sensible in response. I mean, we need to keep looking for alternatives to legal decisions, don't we? And in the Sharma case, the climate case where I was the litigation guardian, I mean, the young people were dismayed by the fact that even though the first decision by Justice Bromberg, I think, said that, yes, the minister did have a duty of care to young people in terms of opening up new coal mines. The decision then was, but the law couldn't stop, or the law wasn't going to stand in the way of her making a decision about continuing or enlarging the coal mine that was in existence and making it, you know, more productive and so on, or simply enlarging it. But the thing that did come out of that, even though there was a moment of sort of very big sadness for the young people in particular, but I thought it was a moral victory because the litigation part of it did not say in the first instance that there was no duty of care to young people, nor did they question any of the data that was put forward. So you have to sort of think, well, okay, they've accepted all of the science and no one's questioned that. And at least initially, yes, the minister has some duty to next generations. So where can we move from there? It won't happen right now, but having had that case, was that helpful in terms of moving from there to the next reality of testing out this stuff? And I think that has happened because even though I'm not directly involved in much of the climate justice stuff, I keep looking at it with great interest. And I see many of the cases now that are being brought forward bring up duty of care in some shape, make or form. Yeah.
I just completely agree, and I think that's the one thing, on the one hand, while I'm talking about reclaiming the judicial lane, you know, at a Mabo implied freedom of political communication level, I'm not saying let's go crazy. It also is part of a broader system, as you say, and you know, Anjali Sharma's work in particular after that decision has been phenomenal. Her advocacy for a duty of care bill is amazing. Her, you know, really deep connections she's built in Parliament are amazing, but also the work, you know, she's done with other communities who are pushing for these fights, including she travelled with Uncle Pabai and Uncle Paul to Vanuatu on Greenpeace's Rainbow Warrior. They spent a month together on that boat, getting to know each other, planning for what comes next. There are so many, I love hearing you speak about the interconnectedness and the relationships, because that's where everything really emerges from. And I think in law you can get really hung up on like who won, who lost, and that kind of piece, but actually the reality is it's much more interactive and emergent than that, and there's so much that comes from those relationships and the connections between people like Anjali and the uncles, and more to come with more litigation that's happening. You know, look at Raylene Cooper, she's fighting at the moment in WA to try and protect a million 50,000-year-old artworks against a gas expansion that's going to destroy them. You know, you look at Gomeroi people, you know, look up in the territory, like there are people all over the country who are doing these things and finding connection and solidarity and meaning in there as well, which is a big part of it.
Hi. Oh. Is this on? Yeah. Hi, Rowena Cantley-Smith. For my colleagues from Monash will remember that I did energy and climate change law for many years before I went to New South Wales. I just want to thank you all. Wonderful presentation. But also wondered if we could maybe have a look at, if I understand correctly, the judicial lane issue. You're predominantly talking about federal courts. And in my experience, and most recently yesterday, the New South Wales Court of Appeal handed down a fantastic decision in which the Upper Hunter Healthy Environment community groups attempt to overturn the largest coal expansion in Australia has been approved. So that's a fantastic win for a community group against a government and the planning decision to arguably make a terrible, terrible contribution to our national emissions, particularly through Scope 3 emissions. But I wonder if part of the problem here with climate change is that what I've seen over the last 2 decades is that energy law in particular is a major source of emissions, Australia and worldwide. There's no constitutional competency for that. So it's state-based laws with some national laws that the states allow the Commonwealth to be involved. So how do we deal with this in climate litigation when some of the states are being really progressive in climate litigation, like this New South Wales case? But getting back to your bigger question of climate litigation and human rights, at the same time, these very same states are passing really restrictive protest laws, criminalising what is essentially basic access to justice and public participation. We see Civic Monitor ranking now Australia as narrow. So we see all these things happening. So I'm just wondering if you could maybe talk a little bit, if it's possible, about the role of climate defenders and what their role is in climate litigation and human rights, seeing how successful the New South Wales group were yesterday. Thank you.
Yes, and big shout out to the new organisation Climate Defenders Network, who are a phenomenal new group that I'm so happy exists, who are really focused on looking after and supporting protesters, particularly climate protesters, in the face of really extreme anti-protest legislation across the country. We also had reports over Christmas that Australia is the most criminalising state on protest of like countries. That's kind of a big deal. So they are definitely part of it, and I want to make sure that I don't mean to suggest that this narrowing of the judicial lane means that the judicial system isn't doing its job. I think it's doing a terrific job. I think that's a really good example, and you win some cases, you lose some. This is not about like, oh, we lost, so the judicial, listen on that. That is a kind of a broader point, talking about like kind of a federal system and how that works. And there are good cases happening, and massive shout out as well to Elaine Johnson and Johnson Legal, who won that fabulous case yesterday. They're also representing Raylene Cooper in her claim in WA. But protest defence is a really big part of this, but you also hit on something else which is an important part of it, which is this litigation should not need to happen. We have a government and governments that are meant to legislate for the public good. It is possible for them to do so. We could have a Human Rights Act, we could have fair and appropriate protest laws. We could have fair and appropriate climate laws. We don't. And so, you know, the framing of this conversation, and obviously my particular lens is litigation, but there are obviously other tools available to us as well, which include, of course, legislative reform.
I'll ask the question. I'm really interested in, do we always have to wait for things to happen that have gone wrong and then there's a court case about it and then there's a precedent set, sort of? How much of a role is there, and where does it come from, to actually get good frameworks for making decisions at a government level and so on, without the court cases having to happen?
It's a very simple question. No, that's a very big question. I think it depends on appetite, doesn't it? It depends on majority, it depends on people and their preferences, it depends on where you are in election cycles, it depends on social movements and social mores. And I had a discussion yesterday with Eleanor Campbell about her sort of career in 10 years working as a ministerial advisor, and my ignorance, I said, and why did you leave? And she said, the government changed. And so, kind of what I was doing, the possibilities that were there for the previous 10 years just went away. And I think that happens a lot. And that's one of the problems where we have this multi-generational issue of climate change, where you see over very short periods of time governments changing, priorities changing, withdrawal from international agreements, and so on. I want to come back to the protest question to make 2 points. One is I've been writing about the lawyers who prosecute those climate activists and what that means, and kind of what I think of those lawyers, which is a fair bit. And the other thing that I'm interested in, actually let me explain that because that sounds very flippant. There comes a point, I think, so every lawyer has the ability to have a view on the content of the law. So you might say, this is what the law is, and I have a strong sense of duty to not challenge the law and to help operationalize it. But you can, in parallel, also have a view about the validity, the quality, the accuracy, the correctness of the law. And I think we sometimes forget that. The other really interesting thing at home, and I'm not sure, sorry, my old home, not what happens here, is last year there was a GP who was convicted for breaching an injunction in relation to climate protesting, and the medical regulator suspended her practice for 5 months because she'd been found guilty of that offence. At the same time, the regulator of solicitors, the Solicitors Regulation Authority, has a guidance document which says, for climate protests, we think these are acts of conscience and we will not take action even if you're found guilty. How fascinating that the medical regulator goes down one path and the regulator of solicitors does something quite different. I find that kind of fascinating because, again, it's coming back to a question from earlier about different actors and groups. How are regulators of doctors and lawyers, etc., responding to these existential questions and where people feel an obligation to speak up, to do something, to protest?
Thank you. I think there's much more we could say about this issue. In some ways, I feel like we've only scratched the surface of the depths and the breadth of the issue. But I hate to stand in the way of a cup of tea for you. So please join me in thanking our panellists. We resume again at 2:40. 2:40. Sorry. 2:40. We'll make it 2:45. 2:45.
6 minutes for a cup of tea.
audience so that while you're talking, it's sort of...
That's fine. That's fine. Can you hear me?
Thank you. We're going to start the final session for today. So I'm honoured to be the chair for the final session on understanding human rights law in the colonial jurisdiction. Trying to get the microphone in a better place. So I'm honoured to be chairing this panel. This panel is going to be a bit more traditional. We're going to hear from the three speakers, and if there's time, we're going to have some questions. First up, and I'll be introducing each speaker one by one. So first, I would like to welcome His Honour Coroner Simon McGregor from the Coroner's Court of Victoria. Prior to being appointed as a coroner in 2018, Simon was a member of the Victorian Bar for 21 years. And on his way there, he was President Winnicke's researcher and a Court of Appeal registrar before he read with H.A. Jake Forrest, had 6 readers of his own and 2 Indigenous lawyer mentees. He both practiced and published in administrative and human rights law, health and regulatory law, inquests, commissions, proceeds of crime and other investigation spaces. So I'd like to welcome His Honour Coroner Simon McGregor to speak first. Thank you.
Thanks, Mark. I'd like to begin by echoing Melissa Castan's acknowledgement of the traditional owners of the land on which we gather, and I pay my respects to their elders past and present, and also to any Aboriginal people with us today. I acknowledge your presence and say thank you for continuing to share your voice with us. The caveat to my talk is that I think it's very boring, but your committee assured me it would be interesting to you. It's boring because, as the previous panel were just describing, having been a judge and having done certain cases, there's a time when everyone has to listen to the judge, and the judge has to say everything that they've got to say about a case when they publish their findings. And after that, it's the judge's time to shut up, and people will make of it what they will. Will it be appealed? What do journalists think of it? What do academics think of it? And so I need to be careful today, and this is the reason why I think it's boring, but I'm not saying to you anything that I haven't already said in a judgment. If I could have the next slide, and this is the only slide. So I'm talking with you about 2 cases where I have mapped human rights law into the coronial jurisdiction. And so, just so you don't need to take too many notes, we've circulated the link to both of those cases. And that's the first case is that of Veronica Nelson, who was an Aboriginal lady who was a drug addict who failed to get bail for an offence that she would never have done any actual jail time for, and then subsequently died in custody from natural causes whilst a small army of people on the taxpayers' dollar stood around and watched. That decision, that finding is 350 pages, but there's a webcast of me reading out the finding, and it's 3.5 hours, but you can listen to it. It's in sort of 1 hour chapters. So if you like podcasts, if you prefer to take this stuff in as a listening thing rather than a reading thing, you can do that. And the second case that I'm drawing on in what I speak to you about today, mapping human rights into the coronial jurisdiction, is called the XY, which is a pseudonym case. And this is about a troubled Aboriginal teenage sex assault victim who spiralled through 10 years of the child protection system before she committed suicide. So that was a 250-page decision. So what the organisers might have achieved for you in giving me 20 minutes to talk about those is that you've got a lot of time in your life back. If all you get to is hearing 20 minutes on it from me, you can make an informed decision about whether this goes any further or not. So I would say, though, too, in the interest of time, and this is me taking a moment as a practising judge to appreciate the role of academic lawyers, I did Nelson first, and then I did XY. But in between, after Nelson, 2 academics well known in Castan Centre circles, I know Bruce Chen is here today, and Anita Mackay, wrote and published a great article analysing the Nelson decision, the human rights perspective on it, and I found that very helpful. And by the time I got around to writing XY, the discerning reader will spot, I think, some refinements and some improvements. I can say neither case, on the charter issues, neither case was appealed at the end of the day, so they both stand. But if you're only going to read one of them, thanks to Anita and Bruce, I would say read XY as a refined template, but also, isn't it great how academic and practitioners can inform and improve each other's work. So I just want to say, I think this conference today, that sort of input is a sign of the success stories. So the cases involve different rights, and with the time I've got available, I can't spend too much on the weeds, the detail, the fine print of the child protection system or the bail, remand and healthcare in prison system. You'll get all that detail in the cases, and you'll also get some extracted parts. If you just want to see how the charter mechanics work, you don't need to read all those hundreds of pages. They're in smaller pockets. But so with that out of the way, and the final caveat being a judge that I need to remind everyone of is I've made those two findings based on the evidence I had and the submissions I had in those two cases. And of course, none of you will be surprised that I might decide something differently next time it happens. All I'm doing is sharing with you a template that so far hasn't been appealed. And if that's of some use to you, great. It follows, though, from how I've lent on this in both these decisions and spent a fair bit of time with the charter stuff, that in my mind, the human rights mechanisms are a very useful lens through which to view the multitude of interactions that the state and its delegates have with individuals within its jurisdiction. So what you've got to do first, and this is applicable in any jurisdiction, but in the coroner's court, is you've got to understand what the coroner's job is. That's just set out in the Coroner's Act. And so it's very simple that I've got to establish the identity of the person, their cause of death, which is often medical, and enough background circumstances to give context to those two other pieces of information so as to allow the better administration, public health planning of the state of Victoria by having accurate information about that. Now, on the way, I'm given what's called a prevention remit. Whilst I'm making those findings, I also have a power to make comments or recommendations about matters that are connected with the death. And through those lenses, you can make comments about prevention. And there's an interesting, I think, very useful overlay there with charter mechanisms. So remember the coroner's job, and then if you're involved in a coronial proceeding, you want to map whichever source of rights documents you're using for the coroner before you get into the subject matter of the inquest. So we're lucky here in Victoria because we've got the charter, and the charter is mostly drawing on those ICCPR rights. But in my XY decision, I was also mapping from the Convention on the Rights of the Child to get to our Section 19 rights of families and children. So don't assume that your judge knows that, but map it for them and map it how it ends up in your domestic law. Right, then the processes that you're going through is, you know that the Charter tells us that all laws are to be as compatible as possible with, consistent with the human rights that are articulated in there, and it requires lawyers to read the laws that way to the extent there's an ambiguity, and it also requires Victorian public authorities to act in a way that's compatible with human rights and to give proper considerations when they're making decisions, proper consideration of human rights. So there's a few different ways then that the Charter influences the job a coroner already has to do. So that's how you map it in there for them. So say when we're looking at a particular circumstance, and what the coroner's mostly doing is finding facts about what went on, you're considering whether a death would be preventable. I will have figured out a few different human rights that I think are engaged. ask whether they are engaged in the interactions that person has with the state. If so, were there rights that you've had to think about? Were they limited at some stage? And if they were limited, were the limitations reasonable and demonstrably justified by some evidence, or whether there were alternative pathways that were available that were more effectively balanced the rights and the limits? So it's that alternative pathways element that really resonates with me as a coroner when I'm exploring a prevention opportunity. So I've done some fact finding, something hasn't worked. Is there a better way it could have been done? One way it might be better, it may be more efficient to do some other way, or it might be better in terms of its human rights compatibility. So there's a nice fit there with the jurisdictional task that I'm doing anyway. So then the Charter influences the law in Victoria by applying to all courts and some of the tasks that they do as courts. It then applies to all public authorities, and most courts aren't very public authority-ish, but because the coroners, or we're inquisitorial, and 90% of what we do is investigative, we're often a public authority. So it applies to the coroner's court that way, and then it also applies on the subject matter of the death that we're investigating, whether it's a death in care or a death in custody. So there, you might, in many cases, all three roads lead to Rome that the Charter applies. So I'm going to consider the rights and step through the process that the Victorian Supreme Court's explained to us. But it is good to have turned your mind to which road to Rome am I on, because sometimes that might affect the outcome. So then, when we're looking at, say, the actions of public authorities, which includes private companies that are contracted to fulfil government tasks, the Supreme Court in the Certain Children No. 2 case gave us a great little template of what to apply. So this is when you've got your subject matter, and you then, what I do to remind myself of the machinery of the Charter, I get Kylie Evans and Alistair Pound's great book out. I go through that for the machinery. Then I'm looking for the detail of this right and that right. And then I love looking at Sarah Joseph and Melissa Castan's great ICCPR book. You get all that stuff ready, and then you step through this analytical exercise yourself, and then it gives you some insight into how that's rights working in relation to your subject matter. So from Certain Children, the first thing we do is figure out, is any human right relevant to the decision or action that a public authority has made, taken, proposed to take, or failed to take? We call that the relevance or engagement question. If so, has the public authority done or failed to do anything that limits rights? The limitation question. If so, is that limit under law reasonable and demonstrably justified, having regard to the matters set out in the proportionality test in the Charter? We call that the proportionality or justification question. Even if the limit is reasonable and demonstrably justified, if the public authority has made a decision, did it give proper consideration to the right? So that's the proper consideration question. And finally, was the act or decision made under the act or the instrument that gave the public authority no discretion in relation to what to do? Or does the act confer a discretion that cannot be interpreted under the Charter in a way that is consistent with a protected right? That's called the inevitable infringement question. It's effectively a defence to say I couldn't do it any other way while still respecting the Parliament that created these laws. So there's substantive obligation in there and procedural obligation, and if either of them are not met, you have unlawfulness under the Charter, you have a right not being appropriately articulated, and then what you will do in that process, when you get to the remedies, the relief, the consequences of finding a charter right not being respected, is there's an interesting quote that I think just the eminent Justice Weinberg put it best when he said in the Sudi case, which was about public housing, he said, it's one thing to characterise non-compliance as unlawful, and that's an easy thing for a coroner to do as you go through finding facts and using the Certain Children analysis. It's quite another to determine what sanctions or remedies might be available. So you need to then come back to the job that your judicial officer is doing. If it's a coroner, I'm finding identity, cause of death, background, circumstances. I can make comments or recommendations in connection with the death. So that's it's a drafting exercise to think where are we getting to? How can we articulate that? So as an example, in the XY decision, one of my conclusions was, so we're thinking about the actions of the department, and in relation to this child, there was a family reunification order in place from the Children's Court, and the department had not acted on that order. So I've said, as we go through all that evidence, to sum up, these two failures by the department to actively consider XY's views about her own best interests, that's the rights of the child, constitute an unjustified and disproportionate limitation of XY's charter right to the protection of her best interests as a child, and thereby constitute unlawfulness under section 38(1) of the charter because the department acted in a way that was incompatible with her right. There's no demonstrable justification here because the attempts or failures to action her voice were not documented by the department. Nor are there any reasonable rationales for not pursuing the sibling access recorded. These are disproportionate because without access to or the hope of obtaining the quality of life that XY herself articulated, far greater resources were continually expended by the department as she lurched from crisis to crisis without a long-term solution in sight. So that's a drafting exercise. I really just used the language of the charter in reaching the conclusion on the facts. There's no relief that arises out of that, but I have the power to make findings at recommendations. I can't force anyone to do anything, but you have to respond to my recommendation, and that's published. So effectively it creates an accountability footprint, and that either is, if it happens again, you can't say you didn't think of that, and it might then impact government decisions about funding, hiring, media reporting, voting, all that sort of stuff. So it creates an accountability footprint, even though I can't make anyone do anything. So some of the stuff in Nelson, some of the charter type findings were, during the bail hearing, I find that the advocate failed to properly consider Veronica's charter rights in that her Aboriginality was not actively asserted in the bail hearing, and that would have put her into a favourable bail category, so she wouldn't have gone to jail. Once she got to jail, they knew she was withdrawing from heroin, but there was a policy at the time that there was no opioid substitution available in jail, even though that is available in the community. So under your right to equality in the charter, she wasn't getting equivalent health care in prison as she would have got out in the community. So I found that the opioid guidelines infringe prisoners' rights to be treated humanely whilst deprived of liberty and their right to life, given the greater risk of a fatal overdose upon release to society, and that's contrary to section 22 and section 9 of the charter. And I also found that the treatment she received constituted cruel and inhumane treatment, contrary to section 10 of the charter. So then you can, as you go through essentially a fact-finding exercise, you can reach some conclusions on those facts that is the wording the charter uses. You're not invoking, it's not a declaration of inconsistent interpretation, that's a Supreme Court constitutional remedy, but it's a fact-finding process. It's a way of summarising those in a pithy way that both lawyers understand and the community understands. And I think I second guess that one of the reasons we're able to alter temporarily the bail laws in Nelson and alter permanently the opioid policies within the jail was the amount of that it was well understood at a common sense level what was wrong here. And that's that challenge of creating, I liked Hugh de Cresta's concept of the policy window, of creating enough interest, which means enough eyeballs, enough votes, to show in plain English why something could be done a lot better, and then to make this comment or recommendation. I'm not making anyone do anything, but it's up to them whether they do or don't. So, so that's your process, and that's the template that I've applied with the help of the people at the bar table and the submissions that I had in both of these. Nelson was appealed, not on the charter point, and unsuccessfully appealed, and XY wasn't appealed at all. So There's about 600 pages worth of reading up there. If in 15 or 20 minutes here, I've saved you some time, it's allowed you to do something great like come to this conference, or who knows how we can all make the world a better place. But for me, that's the utility of this process, is that the reality of human interactions are very complicated and incoherent, and they're a mixture of competing priorities. And for instance, in XY, I read 40,000 pages of child protection notes to try and make sense of that. Human rights analysis provides a lens, a filter through which to remind ourselves what's important, why we're here, and given the coroner's prevention remit, it gives us an opportunity to articulate a better world. Thanks for your attention.
Thank you, Simon. And I think we've all got homework this weekend. And anyone who's doing coronial law next year with me, 600 pages, it's on the reading guide. A plug. I just did a plug for my elective. Can't believe that. I'd like to go to the next speaker, and that's the Honourable Pamela Tate, AMKC. And she's an adjunct professor of law at Monash University and a former judge of the Court of Appeal at the Supreme Court of Victoria. When Solicitor General, she was special counsel to the committee that recommended the enactment in 2006 of Victoria's Charter of Human Rights and Responsibilities. So there's a connection here. She is a director of the Australian Academy of Law, and in 2018, Monash University conferred upon her an honorary Doctor of Laws. She's a former patron of Women Barristers Association and the current patron of the Australasian Association of Philosophy and the Human Rights Law Association. So I'd like to welcome the Honourable Pamela Tate.
Well, thank you very much, Mark, for that warm introduction. Well, I want to address the topic of understanding human rights law in the coronial jurisdiction by taking a step back. The issue I want to address is, in a general sense, how and when did human rights law become relevant to coroners? In effect, I'm asking the question, how did we get here? Well, I want to answer that question by looking in some detail at the right to life. This right is the primary source of the relevance of human rights law to the work of the coroner. Now, Simon has touched on some of this already, but my aim is to take a deep dive into the scope of the right to life and to examine its implications for the coronial jurisdiction. I want to consider first the international law basis of the right to life. I also want to look at two comparative jurisdictions, namely the United Kingdom and New Zealand. In particular, I want to examine a recent New Zealand case, Wallace and the Attorney General, which has dealt with some novel questions that were previously unresolved. This takes us away from the strictures and constraints inherent in the Victorian Charter to a broader view of the relevance of human rights law in this context. Well, as many courts and commentators have observed, the right to life needs to be understood and domestic statutory provisions interpreted in the international context. The United Kingdom looks to the European Convention for the Protection of Human Rights and Fundamental Freedoms as its principal rights-protecting international instrument. Article 2 of the European Convention protects the right to life. It's included in the Convention rights that are given effect in domestic law by the enactment of the UK Human Rights Act 1998. So in the UK, there is no separate domestic statutory expression of the right to life. The UK Human Rights Act simply gives effect to Article 2 in the terms in which it's formulated in the European Convention. This differs from New Zealand, and for that matter Victoria, where the respective parliaments have adopted their own domestic formulations. And later I'll consider whether this difference has any significance. Article 2 of the European Convention relevantly provides, everyone's right to life shall be protected by law. No one shall be deprived of their life intentionally, save in the execution of a sentence of a court following their conviction of a crime for which this penalty is provided by law. Well, New Zealand relies upon the International Covenant of Civil and Political Rights, the ICCPR, as its principal international instrument for the protection of rights and freedoms, and we've heard discussion of that already today. New Zealand's commitment to the ICCPR is affirmed under domestic statute by the New Zealand Bill of Rights Act 1990, New Zealand BORA. The right to life is protected by Article 6 of the ICCPR. This relevantly provides, every human being has the inherent right to life. This right shall be protected by law. No one shall be arbitrarily deprived of their life. Both Article 2 of the European Convention and Article 6 of the ICCPR recognise that the infliction of lethal force by an agent of the state may be justifiable, that is, may be lawful and not arbitrary, if necessary and proportionate, for example, in self-defence. Well, despite the differences in the language between Article 2 of the European Convention and Article 6 of the ICCPR, they are viewed as generally having the same effect, as they both aim to implement the Universal Declaration of Human Rights. This has led to cases from one jurisdiction being relied upon in the other. In particular, cases from the European Court of Human Rights or the UK Supreme Court are often relied on in New Zealand. When it came to the New Zealand Parliament's intention to affirm the rights under the ICCPR, it chose to modify the language of the right to life as formulated under the Covenant. Section 8 of New Zealand BORA, the statutory expression entitled life, provides, no one shall be deprived of life except on such grounds as are established by law and are consistent with the principles of fundamental justice. Well, the principles of fundamental justice prohibit, in particular, arbitrariness or gross overreach. Well, of course, it's the ICCPR that also serves as the model for the rights protected under the Victorian Charter. The Victorian Parliament also modified the language so that Section 9 of the Charter, entitled Right to Life, reads, every person has the right to life and has the right not to be arbitrarily deprived of life. Well, neither Section 8 of the New Zealand BORA nor Section 9 of the Charter include the words that the right to life shall be protected by law, words found in both the European Convention and the ICCPR. The New Zealand Court of Appeal and Wallace and the Attorney General recently had to grapple with the question of whether the omission of those words, shall be protected by law, has an impact upon how the right to life is to be interpreted and what obligations it gives rise to on behalf of the state. It had to answer the question whether the right under the New Zealand BORA is equivalent in scope to that under the ICCPR. Well, the primary means of identifying the scope of rights under the ICCPR is to look to the general comments made by a specialist body of independent experts for which the Covenant expressly provides, the UN Human Rights Committee, that monitors its implementation. In its most recent version of the general comment on Article 6 in 2019, the committee observed that the right to life is the supreme right. It has crucial importance both for individuals and for society as a whole. It is most precious for its own sake as a right that inheres in every human being, but it also constitutes a fundamental right, the effective protection of which is the prerequisite for the enjoyment of all other human rights. The scope and protections afforded by Article 6 are far-reaching. The UN Human Rights Committee said it lays the foundation for the obligation of states to respect and ensure the right to life, to give effect to it through legislative and other measures, and to provide effective remedies and reparations to all victims of violations of the right to life. The committee recognised that respect for the right to life involves a negative obligation of restraint on behalf of the state, a prohibition against the state engaging in the arbitrary deprivation of life. This responsibility extends beyond the actions of state actors who actually administer lethal force and includes any loss of life for which the state may be held accountable. As the committee observed, respect for the right to life entails the duty to refrain from engaging in conduct resulting in arbitrary deprivation of life. State parties must also ensure the right to life and exercise due diligence to protect the lives of individuals against deprivations caused by persons or entities who are not state agents. This extends to reasonably foreseeable threats and life-threatening situations that can result in loss of life. The general comment acknowledges the special duties the state has to people who are incarcerated or otherwise detained. A duty of care is recognised to take any necessary measures to protect the lives of individuals deprived of their liberty by the state, since by arresting, detaining, imprisoning or otherwise depriving individuals of their liberty, state parties assume the responsibility to care for their lives and bodily integrity. An example of this is the famous case of Amin and Secretary of State. There, the House of Lords held the state responsible for a breach of the right to life when a young person in custody was murdered by a cellmate with a history of violent and racist behaviour. Well, in addition to the duty to protect against deprivation of life and life-threatening risks, the right to life also gives rise to positive duties. Relevantly, there is an implied positive obligation under Article 6, the ICCPR, on behalf of the state to investigate certain deaths. This has been described as a right to a thorough investigation of deaths. This means that where a death occurs and the state is implicated as being responsible, there is a further requirement of an independent and thorough investigation. In Amin, Lord Bingham described the scope of the implied positive duty to investigate. He did this in a manner endorsed in 2025 by the UK Supreme Court in Inri Dalton. Lord Bingham explained that the essential purpose of a human rights compliant investigation is to ensure as possible that the full facts are brought to light, that culpable and discreditable conduct is exposed and brought to public notice, that suspicion of deliberate wrongdoing, if unjustified, is allayed, that dangerous practices and procedures are rectified, and that those who have lost their relative may at least have the satisfaction of knowing that lessons learned from their death may save the lives of others. In general, an investigation should involve a degree of heightened scrutiny and to extend to an examination of the surrounding circumstances. It may extend to circumstances where loss of life is an indirect consequence of a state action, for example, through the manner in which a police operation is planned and controlled. As the European Court of Human Rights said in McCann in the United Kingdom, deprivations of life must be subject to the most careful scrutiny, particularly where deliberate lethal force is used, taking into consideration not only the actions of the agents of the state who actually administer the force, but also all the surrounding circumstances, including such matters as the planning and control of the action under consideration. Well, the investigations required by the right to life may take various forms, including criminal prosecutions and coronial investigations and inquests. Relevantly for the coronial jurisdiction, General Comment 6 goes on to describe the importance of the investigation, identifying the deceased and arriving at the truth of how the events led to the death. It says, where relevant, the investigation should include an autopsy of the victim's body, whenever possible, in the presence of a representative of the victim's relatives. State parties need to take, among other things, appropriate measures to establish the truth relating to the events leading to the deprivation of life, and identify the bodies of the individuals who have lost their lives. State parties should also disclose relevant details about the investigation to the victim's next of kin, allow the next of kin to present new evidence, afford the next of kin standing in the investigation, and make public information about the investigative steps taken and the findings, conclusions, and recommendations emanating from the investigation. The recommendations are to assist, as Simon mentioned, by identifying steps to prevent the occurrence of similar violations in the future. Well, we can now pause for a moment to reflect with some precision on how the right to life, as protected at the level of international law and affirmed in domestic law in the United Kingdom and in New Zealand, how that is relevant to the work coroners undertake. It's clear from the material canvassed that the coronial jurisdiction may be an important means by which the state carries out its positive investigative duty, implied under the right to life, to thoroughly investigate deaths in which the state is implicated or for which the state should be held accountable. That is, coronial investigations and inquests may be a means by which the state discharges its obligation to protect the right to life. Crucially, this imposes human rights standards which coronial investigations must meet in order to discharge that obligation. So human rights law is relevant because if the work of the coroner is to discharge the investigative obligation implied by the right to life, it must meet human rights standards. The international case law indicates that an inquest will often be the most apt and rights-compliant investigative form where the state is implicated in a death. However, whether in a particular case a coronial inquest meets the requirements of Article 6 of the ICCPR will depend upon how it is conducted. This will depend upon the facts of the case and the course of events at the inquest itself. Well, turning then to the case of Wallace and Attorney General. This case is a good illustration of the close inspection a court will engage in to determine whether a coronial investigation meets human rights standards, the requirements of Article 6. Heard in 2021, this was the first case to consider the nature and extent of the Crown's obligations under Section 8, the right to life, in the New Zealand Bora. The case arose because a police officer in New Zealand shot dead a 23-year-old man, Stephen Wallace. In the early hours of one morning, Wallace went on a violent rampage through a small rural town. He used a baseball bat and a golf club to smash the windows of the police station. He also smashed a police car driver's side window and windscreen, as well as shop windows. He threatened bystanders, including by smashing the driver's window of a passing taxi. 2 armed police officers approached and attempted to reason with him. One of them yelled, "Armed police, drop your weapons." Wallace did not back down. Rather, he advanced on one of them, Constable Abbott. Abbott was forced to retreat, moving backwards. Wallace yelled, "You've pushed me too far," and that he was going to kill Constable Abbott. He held on to the baseball bat and threw the golf club at Abbott. Abbott fired a warning shot in the air. Wallace continued to advance. Abbott shot him dead. Numerous investigations followed. They included a police investigation, a depositions hearing, and a criminal trial brought as a private prosecution by the family against Constable Abbott after the Crown decided not to prosecute him. The private prosecution resulted in an acquittal on the ground of self-defence. In addition, there was a coronial inquest and an investigation by the Independent Police Conduct Authority. When all these inquiries had been completed, Wallace's mother brought civil proceedings against the Crown in New Zealand's trial court, the High Court, claiming that the events of that night breached Stephen Wallace's right to life under Section 8 of the New Zealand Bora. She alleged that none of the investigations undertaken were adequate to give effect to the right, and nor were they adequate when considered cumulatively. It was accepted that the core of the right to life was engaged because Wallace was killed by an agent of the state. However, the trial judge, Justice Ellis, noted that Section 8 of the New Zealand Bora had not generated jurisprudence proportionate to its importance, and that many of the questions raised were novel, at least in a domestic context. One of those novel questions, and this is what I flagged earlier, was whether Section 8, the statutory domestic expression of the right to life protected under the ICCPR, generated an implied positive duty to investigate a death in which the state was implicated. It was accepted that, as we've explored, in international law, the right to life gives rise to an implied positive investigative duty. However, the question for the court was whether the right, as expressed in the New Zealand Bora, impliedly generates the same duty. The question was crucial to the viability of the proceeding, and it required a determination before any assessment of the facts or potential liability of the state. The question arose because of the drafting differences I mentioned earlier between the right in the international instruments and the expression of that right in domestic law. Crucially, as I highlighted before, Section 8 of the New Zealand Bora does not include the words that the right to life shall be protected by law, words that appear in both Article 6 of the ICCPR and Article 2 of the European Convention. The argument in Wallace was that it was those particular words, shall be protected by law, that established the basis for the implied obligation to investigate, and in their absence, no such positive investigative duty is to be implied. Well, the New Zealand Attorney General submitted that there were a number of statutory mechanisms in New Zealand aimed at ensuring that the relevant investigation would occur. In those circumstances, it was argued, there was no justification in recognising a further implied positive obligation to investigate derived from human rights legislation. Justice Ellis dealt with this important question first by querying how the right to life in the New Zealand Bora would be vindicated if the available statutory processes proved inadequate in any particular case by reference to human rights standards. She also accepted that while the duty to investigate may be linked to the duty under law to protect life, it is also linked to the obligation not to take life unlawfully. That is, the right every person has not to be deprived of their life. She focused upon the purpose of Section 8 and said that to achieve the purpose of protecting life, it makes sense for a protective obligation to arise regardless of the way in which the right to life is expressed. For this proposition, she relied on observations made by Baroness Hale in Savage and South Essex NHS Trust that one of the duties arising from the right to life is an implied positive duty properly and openly to investigate deaths for which the state might bear some responsibility. This is because, Lady Hale said, there is not much point in prohibiting police and prison officers, for example, from taking life if there is no independent investigation of how a person in their charge came by her death. In other words, the prohibition on taking life will have little effect unless there is the threat of an independent investigation when a life is taken. Justice Ellis concluded that the reasoning of Lady Hales applies with equal force and logic to Section 8 of the New Zealand Bora. She went on to focus upon the purpose of Section 8 and why it's necessary to interpret that section in accordance with its purpose. She said, "The prohibition on depriving others of life is toothless without a parallel obligation to interrogate and test the circumstances in which such a deprivation has occurred in the individual case. As with Article 2, the interpretation of Section 8 must be guided by the fact that the object and purpose of the Convention as an instrument for the protection of individual human beings requires its provisions to be interpreted and applied that makes its safeguards practical and effective." She continued, "In my view, therefore, a purposive interpretive approach to Section 8 not only permits but requires the inclusion of an obligation to investigate a death that has occurred at the hands of a state actor." Well, the New Zealand Court of Appeal agreed with Justice Ellis that the right to life, within the terms of its domestic statutory expression in Section 8 of the New Zealand Bora, impliedly gives rise to a positive duty to investigate, despite the absence of the words that the right to life shall be protected by law. The court said there is in Section 8 an implied right to have an ICCPR-compliant investigation into potentially unlawful deaths for which the state may be held accountable. The rights exist as a necessary incident of the right to life affirmed in Section 8. Coroner's investigations which must happen where life has been lost at the hands of a police officer acting in the course of duty should ordinarily meet the state's investigative obligation. The court added, whether any given death has been effectively investigated seems to us a mixed question of law and fact, which must be answered in context. The Court of Appeal also upheld the decision of Justice Ellis in identifying the content of the duty to investigate, that is, what human rights standards should apply. Justice Ellis held that the obligation to investigate does not require a particular kind of investigation, but one that is adapted to the particular circumstances. What is required is a matter of substance and not form. She accepted that the requirement for a rights-compliant investigation can be fulfilled through a combination of different inquiry processes, as the fact-finding and accountability components of the investigation obligation may be shared between authorities, including coronial and criminal authorities, provided they are procedurally effective in totality. Relying on Jordan and the United Kingdom, Her Honour pointed to the need for a rights-compliant investigation to be independent, effective, reasonably prompt, have a sufficient element of public scrutiny, and in all cases involve the next of kin to the extent necessary to safeguard their legitimate interests. Well, what do those requirements mean? Independence requires a separation and a practical independence from those implicated in the events under investigation, including an absence of any hierarchical or institutional connection. Inherently, investigations and inquests by coroners clearly satisfy this requirement, the coronial system being institutionally established as an independent body. Effectiveness means that the investigation must be capable of leading to a determination of whether any force used was or was not justified in the circumstances. Any deficiency in the investigation which undermines its ability to establish the cause of death or the person or persons responsible will risk falling foul of the standard. The investigation need not deliver those outcomes, but it should be a means of achieving them. As the House of Lords observed in Middleton and West Somerset Coroner, omitting to make a finding on a major issue may both fail to meet the expectations of the next of kin and risk failing to identify systemic failure to protect human life, and that would be inconsistent with the objects of the Convention. Promptness not only requires that the investigation be undertaken with reasonable expedition and carried out with reasonable speed, but also that it be initiated by the state and not dependent upon the initiative of the next of kin. Accountability means that both the investigation and its results should be subject to public scrutiny in a practical way. The requirement for the involvement of the next of kin is important. Investigations have been vitiated as inadequate, where the parents of a deceased could only attend when giving evidence, were not represented, were unable to put any questions to witnesses, and had to wait until the final version of an inquiry report to discover the substance of the evidence of what had occurred. It was held that the procedure adopted did not involve the parents to the extent necessary to safeguard their interests. Her Honour recognised that an inquest, which is open, independent, transparent, and takes place with family involvement, is likely to be the appropriate vehicle for a rights-compliant inquiry of this kind, particularly by comparison with investigations by police agencies. However, she was aware that an inquest may not always satisfy the criteria. She applied each of the requirements of Section 8 to the multiple inquiries that investigated the death of Stephen Wallace. She found that they did not individually nor collectively discharge the state's investigative obligation under the New Zealand BORA. She held that in the ordinary course, a criminal trial is an effective procedure for finding relevant facts and attributing criminal responsibility, and if relevant, can be relied upon in subsequent inquiries, including those by a coroner. However, she considered that a private prosecution was not capable of discharging the investigative duty because the obligation to investigate rests on the Crown, not the family of the person who has been killed. This meant that in the circumstances of the case, the later inquiries that relied on the findings in the private prosecution could be tainted and ineffective. Specifically focusing upon the inquest, Her Honour held that it was independent, accountable, and had appropriate involvement by the family. As for promptness, the inquest was adjourned pending the private prosecution, and when it resumed, it was necessarily delayed by an unsuccessful application for judicial review. The critical issue was whether the inquest met the requirement that it be effective. Her Honour held that the inquest was ineffective for one reason only, namely that the coroner did not inquire into whether the level of force was justified. Rather, the coroner, treated the jury's verdict in the private prosecution as having conclusively established self-defence, despite the fact that the criminal trial in the case was not adequate, in her view, to meet the Section 8 investigative obligation. As it happened, she went on to determine for herself, on the evidence available, that the killing had occurred in self-defence. On appeal, the Court of Appeal held, contrary to Justice Ellis, that a private prosecution is capable of meeting the state's obligation to investigate a deprivation of life and establish whether it was justified. This is because, as the Court of Appeal commented, although the state did not initiate the prosecution, the proceeding rested almost entirely on infrastructure provided by the state. Depositions were held, an indictment was presented, a judge was assigned and a jury impanelled to treat the case, Constable Abbott was arraigned, witnesses were compelled, the trial was designed to establish and did establish what happened and whether Constable Abbott was criminally liable for it. If found guilty, he would have been sentenced. All of this was done by the state at the instance of the private prosecutor. The Court of Appeal thus reversed Justice Ellis on this point, holding that the inquest satisfied the criteria that it be effective. the coroner was entitled to treat the private prosecution as equivalent to a criminal trial, including the findings arrived at on self-defence. Well, as I've discussed, the Court of Appeal otherwise upheld the view that an implied obligation to investigate arises under Section 8 of the New Zealand BORA, despite the way the right has been formulated, and endorsed the human rights standards that a Section 8 investigation has to meet. Overall, the Court of Appeal upheld the inquest as rights compliant. In 2023, the New Zealand Supreme Court dismissed an application for leave to appeal. Well, to make a final point, I think we can agree from an examination of the New Zealand case of Wallace and the background of international law that in the Australian jurisdictions that have specific human rights legislation, there is much yet to be explored about the scope and importance of the right to life. Thank you.
So we're just going to hear from our last speaker via Zoom, George Newhouse, who's a leading Australian human rights lawyer and an adjunct professor of law at UTS and Macquarie University, and the CEO of the National Justice Project. A tireless advocate for social justice and law reform, he's best known for fighting for marginalised communities, including refugees, detainees, people with disabilities, and First Nations peoples. And so do we have George up on the screen? Thanks, George. And just letting everyone know that we will be going slightly over the projected end time of 4 p.m, and hopefully we'll have some time for questions as well. Thank you.
Well, I'll try and keep it short. Oh, I am getting... You all hear me? Yes. Okay. First of all, I also want to acknowledge that I'm coming to you from our Sydney office, which is on the lands of the Gadigal people of the Eora Nation. Some of the cases in this presentation may cause distress. I'm not planning on going into them in detail, but we're talking about the coronial jurisdiction, and some of them can be distressing. And they also include the images of Aboriginal and Torres Strait Islander people who are now deceased. For those of you that don't know the National Justice Project, we work to create systemic change and amplify the voices of communities that are harmed by government inaction and discrimination. And one of the ways we do this is through strategic litigation, and in particular through inquests. And we see inquests through a very different human rights lens to the two previous speakers. Our experience is really from the perspective of the families and the deceased. Now, the coronial jurisdiction is not just one of the oldest jurisdictions in Australia, but one of the oldest in the English legal system. It's a strange artefact to be using to drive change, but I hope that this presentation will explain how the court became such a powerful institution in the context of human rights, and why the court is currently under attack by the Chief Minister of the Northern Territory, and some of the problems with more conservative coroners' courts. And I'm not talking about the Victorians in particular. Coroner McGregor is an exemplar and a light amongst the coroners in our nation. You might ask why the National Justice Project uses inquests to drive change. And I think the answer is because coroners' recommendations can have profound social impact. And that potential was recognised by the Royal Commission into Aboriginal Deaths in Custody. In the early 1990s, after the Royal Commission, states and territories began to respond to the recommendations by implementing sweeping coronial reforms. Now, I'm not suggesting that all the Ricky-Dick recommendations were implemented by governments, because they weren't. And a lot of people have died because they weren't. But the recommendations about post-death investigators being empowered, not just to determine the cause and manner of death, but also to investigate systemic issues and to make prevention-focused recommendations, were generally implemented. Now, on the screen, you can see recommendation 13 from the Royal Commission that a coroner inquiry into the death in custody be required to make findings as to the matters which the coroner is required to investigate and to make such recommendations as are deemed appropriate with a view to preventing further custodial deaths. The coroner should be empowered further to make such recommendations on other matters as he or she deems appropriate. These were quite profound recommendations at the time. The powers that Coroner McGregor exercised in Veronica Nelson and XY were not available to coroners before 1990. I think that Coroner Alastair Hope from Western Australia summarised it well. He said the Royal Commission provides a timeless reminder that every avoidable Indigenous death calls upon us to identify the underlying causes, consider Indigenous disadvantage, uncover the truth about the death, and resolve upon practical steps to prevent others. Sadly, some of the coroners that followed Coroner Hope in Western Australia have not always lived up to that standard. But like Coroner McGregor in XY and Veronica Nelson, Coroner Elizabeth Armitage did put those Royal Commission recommendations into practice. She recently delivered findings that the shooting death of 19-year-old Kumanjai Walker was avoidable and that the then Constable Zachary Rolfe harboured racist attitudes that could have contributed to his decision to shoot Kumanjai Walker. The inquest also found that Rolfe had used unnecessary force on prior occasions and noted normalised racism in the Alice Springs police station, though she stopped short of finding systemic racism across the NT police force due to insufficient evidence. The coroner made 32 formal recommendations aimed at police reform, addressing racism, including strengthening the NT Police's anti-racism strategy, enhancing community support and engagement, and enhancing police accountability through improved complaint processes. So without detracting from the wonderful work of those present today, I just want to cite one example of how inquests can be impactful. The National Justice Project represented Leanne Little, who was a witness at the Kumanjai Walker inquest. When she gave her evidence, Leanne was a former police officer and she directly contradicted the evidence given by the NT Police Assistant Commissioner to the coroner. The Assistant Commissioner claimed that there was no systemic racism in the NT Police Force. Leanne's controversial evidence led to an apology from the NT Police Commissioner to First Nations people at the Gama Festival in that year, and the introduction of an anti-racism policy for the NT Police, which is now being prepared and implemented by Leanne Little. And I really believe that that came from Leanne's evidence at the Kumanjai Walker inquest. However, not all coronial findings are well received. The Northern Territory Chief Minister does not like the recommendations of the coroner. She stated on FM radio that her government is considering changes to the Coroner's Act as a result of the Walker inquest, which would be astounding, taking us back to pre-1990 legal status of coroners. And for those that don't see systemic prejudice, I'm quite convinced that the Chief Minister of the Northern Territory will not accept that there is systemic racism in the NT Police Force. Like a lot of people, I'm sure that she sees prejudice as an individual issue and the result of a few bad eggs. But coronial inquests have provide an opportunity to look deeper into systemic issues. And I thought you might like to see one example of systemic discrimination that Leanne Little provided to the Coroner's Conference in Alice Springs last year. Now, I don't know whether you can see those details clearly, but what you can see in the top, on the top graph is the rise of Aboriginal prisoners since 1996, which was the election of the Howard government. So changes in the law and in policing and policy since 1996 has seen an exponential growth in Aboriginal prisoners. Now, the orange line down below are non-Indigenous prisoners, and you can see there that they're virtually unchanged. Virtually unchanged. And I think it demonstrates how the introduction, and the blue arrows are increasingly difficult legislation that criminalises Aboriginal communities. And you can see at every point the number of Aboriginal prisoners increases. Now, this chart does not include the current legislative changes that the new Country Liberal Party has introduced. And I think that the gap between Indigenous and non-Indigenous prisoners is going to grow even greater. Now, I do want to quickly deal with the need for reform. I think Victoria and now New South Wales do have exemplary coronial systems, but not all coronial jurisdictions are as perfect or as effective as what we've heard today or seen recently in the NT. The majority also do not have to apply human rights considerations. You're fortunate in Victoria to actually have a Human Rights Act. We don't have one in New South Wales, neither do most states and territories. And it's our view that culturally safe inquests should be mandated and that they should not have to rely on the goodwill of individual judicial officers. On the screen, you can read some feedback from an advocates group who made a submission to a review of the ACT Coroner's Court. Now, whilst they acknowledge that there are some people that have positive experiences, most felt re-traumatised, stigmatised, disadvantaged, unheard, dismissed and sidelined throughout the process. And I think that's not an uncommon phenomenon in some states and territories, not present company accepted. And we've been calling for that national standards to be introduced to ensure that people's journey through the coroner's court is not traumatic, is not stigmatised, and that people are heard. And I've been involved in inquests into the deaths of dozens, I think nearly 100 people, because that includes this Civ 221 boat disaster. And what families and communities tell me is what they want from the court is up on the screen, but it's really respect, a voice, to hear the truth come out, to see real change that comes from the inquest so that no one has to experience what that family has, and for there to be accountability and finally closure. Sadly, they rarely get what they call justice, but that's, but that's not always because of the manner in which the coroners conducted the inquest or in their very miserable findings or recommendations, but because of the limits of our colonial legal system. You know, there are limits to what a coroner can do, and most people don't believe that they receive a form of justice from that process. When I say most people where there's a death in custody or a death where there's allegations of systemic discrimination. And I think one way to meet the needs of First Nations families in particular is for the Commonwealth to establish a First Nations-led investigative organisation to work with state and territory police and coroners around our nation on post-death investigations. The National Justice Project is currently acting for the family of Kumanjai White, who died in a Coles supermarket in Alice Springs at the hands of police, and his family are complaining publicly that the relationship between First Nations people and the NT police is completely broken, and they don't trust in police investigating police, and they want an independent investigation. And you can see on the screen that the response to that is no. But to add insult to injury too, they're confused about the role of the police, because not only are the police investigating the conduct of the officers on the day from a criminal perspective, but they're also acting as investigators for the coroner. And there's a real confusion about, am I talking to a police officer in relation to a coronial investigation or a criminal investigation or some other disciplinary investigation? And for First Nations people, it is time for an independent organisation who can work with coroners, who can work with police forces around the country, but to provide a trusted body for First Nations people. Now, I think we've gone over time. I did have some examples of particular problems with particular jurisdictions and some other cases, but I think given that we've run over time, I might end my my piece there, and I'm very happy to answer questions if there are any.
Thank you, George. So we do have about 8 more minutes, so we can take 1 or 2 questions from the audience if the panel would like to join us up. Yeah. And if we've got some microphones. Yes.
Okay. Thanks very much. Thanks very much to all the speakers. That was really interesting. I just, assuming that all of these right to life obligations are in Australia and New Zealand at least stemming from the ICCPR, Article 6 at the international level has horizontal application. So the state is supposed to, it's not responsible if private person A kills private person B, but it is responsible for not doing what is reasonable to stop that from happening and not investigating, etc., etc. So that's the situation at the international level. Moving to the domestic level, Pamela, you've explained that the relevant words in the BORA have been interpreted as including the positive obligation, even though it doesn't have the exact same words. And I'm assuming that that would be the same, Simon, for the Victorian Charter, or we hope, because the reasoning would be the same. And so my question is that now the Victorian Charter applies explicitly to public authorities. It doesn't necessarily have horizontal application, but the Coroner's Court is a public authority. I think your exact words were that you're very public authority-ish most of the time. So I'm just wondering that we've had an emphasis today on deaths in which the state is involved. In the second case, which you didn't talk about as much, Simon, I'm guessing that could be neglect. You can still have the sin of omission as well as commission. In fact, there was a sin of omission in the first example. But human rights, I'm just thinking in a case of the coroner investing a death where there really is sort of nothing to do with the state. Take the mushroom case, for example. I mean, that there's been a conviction there, so that's different. But if there had been no conviction, you've explained to me, that would have gone to the coroner's court. So could human rights apply in that situation? Clearly nothing to do with the state, or at least we think, and just simply by the basis that you, the coroner, are a public authority.
I'd say yes. I can't give an advisory opinion, but yes.
Also, of course, you know, the domestic legislation that has to be considered includes, obviously, the Coroner's Act, and from memory, that includes unnatural deaths and so on that are otherwise not explained. So it has its own jurisdiction. The question is really, why is there an overlay of human rights standards upon that? and in Victoria and in New Zealand and in the UK and so on, there is an overlay that coroners' inquests in particular, which of course are an ancient institution, but they now, because of that human rights legislation, have to meet human rights standards. So that's where the sort of, if you like, the sort of added value comes in. Well, the types of deaths that the coroner inquires into are obviously deaths in respect of which it otherwise has jurisdiction under the coroner's legislation.
That's quite right, Pamela. And so our jurisdiction's triggered when we get a report of a death, and that means a death. Essentially, it's unexplained, unexpected, but no one's written a death certificate for it. So there's not a doctor standing nearby that can go, yeah, that's what you died of. If not, that's a reportable death, and that invokes our jurisdiction to then investigate it and in certain circumstances have an inquest court hearing. But yep, very public authority-ish. Thanks.
It's a complex question is all I'm going to say.
Are there other
question.
questions from the audience? Yeah.
Hi, my name's Farinaz. I'm from the Victorian Equal Opportunity and Human Rights Commission. We're currently doing an independent review on the recommendations from the Veronica Nelson passing. I just wanted to comment and ask a question. It seems, Coroner McGregor, not all coroners are as confident in, I guess, referring to the Charter in as much detail as you have. What's your view on what would, I guess, support reference to the Charter, I guess, more in the coronial jurisdiction? Is it that parties need to raise it? Do we need judicial education on the Charter?
Pamela is very qualified to speak about the judicial education on the Charter. It is, in both those decisions here, I spent a bit of extra time setting out a template or a process or a method that some people wouldn't have needed to read, but it was just my observation of the world of practicing law that plenty of people still didn't really understand it. So I unpacked it as much as I could. To get to do a human rights analysis, it takes more work. So the cases where I think it's useful to my inquisitorial jurisdiction is where there's a Gordian knot of entangled competing priorities, and this is a filter or a lens to sort out what should be important and what's not. And it's an agreed upon rational process reflecting values that Parliament has told us should be used anytime the law is in operation here in Victoria. So I am looking for, it's present, it should be present in every decision we make, but when it's worth doing a deep dive, when you're going to get a return for that deep dive, I think are the ones where there's not a common sense answer right in front of you. In fact, there's conflicting and competing priorities, so it helps you sift them.
Well, perhaps I could just add that I think in many ways it is incumbent on the parties, certainly in a strictly curial context, that is a court context, for the parties to identify which particular human rights they rely upon and how they say that impacts the litigation. Because it's very, very difficult for a court, as it were, to take the initiative on those things. And I think you'll find there's many a judgment has been written, including in the Court of Appeal, where there's at least a footnote that says a charter right may have been relevant to this issue, but that issue was not ventilated before us. So I really sort of throw it back as somewhat different, obviously in an inquisitorial context. But certainly in an adversarial context, it's really incumbent on the parties to do the hard work of thinking which particular rights might be relevant and how might it affect the litigation.
Thank you. Well, we've run out of time, and so unfortunately I can't take any more questions. I'd like to thank the panellists again for a great session. So. And So thank you, and I'm just going to welcome back Melissa Carson to close today's conference.
Thank you, Mark.
Thank you.
You can have a seat if you want, because you didn't hear one before. Get off. I'm kidding. I love him. He's gorgeous. I just wanted to wind up very quickly. And again, thank you very much for your presentations. And thank you, George, I think probably still out there in the internet. But I wanted to thank you, our audience, for attending today and contributing to such informed and important conversations. And I'm pleased to see how many people have stuck with us to the end of the day, which is quite a feat. And thank you to the people online who've stuck through the whole day. And I really hope you can come and join us in person next year. Your support of the Castan Centre makes the work that we do possible, and we encourage you to support our work to advance human rights by making a donation, if you possibly can, to the Castan Centre. I don't know if there's a slide coming up with the QR code, but it will be on your program and in your information you got by email. We're very grateful for the support of the law faculty and the university, but we also rely on all of you in many different ways. Now, a little bit of housekeeping. If you require an electronic certificate of attendance for your study or professional development needs, then please complete the post-event survey that we have for you. Is it on a slide, Scott, or maybe not this time? Well, maybe it is and maybe it isn't, but it is there on the program down in the corner, and it will be on our website, and you will get an email from us probably on Monday that includes the survey. And in that survey is the request for the certificate that I know some of you are looking forward to for your CPD points. And just upon leaving, I just want to remind you that a lot of you put things into the coat check place. Don't leave without those things, please, because I don't know how you ever retrieve them after that moment of leaving this building. So thanks very much to our awesome team, Gina, Gabby, Scott, Bridget, James, the other people in the media team, and our student volunteers who have been awesome today. Thanks very much to the team from the State Library, both in the catering department and upstairs in the AV up there. And I want a special thanks to my fellow chairs, Mark, Paula and Scott, who have been awesome. A round of applause for everyone. Thank you. I really hope you stick around for a few minutes and make one last friend or connection with someone. Have a restful weekend. Do not read any news. Do not look at the internet. It's worked for me so far. And go well in human rights. Thank you very much.